this table. I suspect that she understood that there would be some differences of opinion, and we hope to be respectful with that. And with that, introduce the Honorable Gina McCarthy, the Administrator for the U.S. Environmental Protection Agency here in Washington, D.C. And ma'am, you're ready to go whenever you are. And again, thank you for being here.
Thank you, and good morning, Chairman Conaway and Ranking Member Peterson, as well as members of the committee. I really want to thank you for the honor and opportunity to be here with you this morning. As stewards of the land, the EPA and farmers share a common goal in protecting our environment. As lifelong conservationists, farmers, ranchers, and foresters' livelihoods depend on healthy land, clean air, and water to produce the food, fuel, and fiber that we rely on. In the 45 years since the EPA's founding, we've cleaned up 70% of our nation's air pollution and hundreds of thousands of miles of waterways. All the while, the economy has tripled. Agriculture advanced too, achieving better yields with less water, lower risk pesticides, and less fertilizer. I'd like to highlight some of the EPA initiatives furthering our common goals. Working with USDA and partnering with the pork and dairy producers and technical experts, we recently launched an initiative promoting recycling nutrients from livestock waste. Annually, livestock produce and manage more than 1 billion tons of manure, but that contains valuable nitrogen and phosphorus, which, if we harness as a renewable fertilizer, can minimize water pollution and build healthy soils. Participants will be challenged to use the power of competition to turn innovative concepts into designs and ultimately into working technologies, creating the solutions that are a win for farmers, the environment, as well as our economy. The EPA also partners with USDA with the Local Foods, Local Places project, promoting walkable, healthy, and economically vibrant neighborhoods through farmers markets, co-ops, community gardens, and other local food enterprises. By focusing development in existing neighborhoods, we help support farm economies and protect undeveloped rural lands. Last month, we announced 27 new communities, raising the total number of communities served to 62 in 29 states just since the program started in 2013. The Clean Water Rule, which we finalized last year, protects the streams and wetlands that 1 in 3 Americans rely on for drinking water, and farmers and ranchers also need for their crops and livestock. As members of this committee know, recent Supreme Court rulings created uncertainty regarding the application of the Clean Water Act to streams and wetlands. In developing the rule, the EPA and the Army Corps of Engineers responded to requests to define the scope of the Clean Water Act more clearly, more predictably, and more fairly. In doing so, the Clean Water Rule not only maintains current statutory exemptions, it expands regulatory exclusions from the definitions of waters of the United States to make it clear that the rule does not add any additional permitting requirements on farmers and ranchers and promotes their voluntary efforts to protect and enhance clean water. We continue outreach to the agriculture community, responding to their concerns, answering their questions, and reinforcing the fact that all existing agriculture exemptions and exclusions continue to apply under the Clean Water Rule. Last year, the EPA finalized volume standards for the Renewable Fuel Standard Program for calendar years 2014, 15, 16, and a volume requirement for biomass-based diesel for 2017. The final requirements boost renewable fuel production and provide for robust, achievable growth of the biofuels industry. Overall, this final rule requires that total renewable standards grow by more than 1.8 billion gallons from 2014 to 2016, requiring 11% more biofuel production than the market produced in 2014. Our 2016 Advanced Fuel Standard is nearly 1 billion gallons, or 35% higher than 2014 actual volumes. The biomass-based diesel standards increases every year to reach 2 billion gallons by 2017. That's a 23% increase over 2014 actual volumes. The EPA took steps to improve the administration of the RFS program and continues to approve new agricultural feedstocks, increasing the number of pathways that biofuel producers may use to qualify their biofuel under the program. We improve the quality, transparency, and efficiency of our petition review process for new biofuel pathways and conducted life cycle analysis on several new feedstocks. The EPA remains committed to the Renewable Fuels Program in meeting Congress's intent to responsibly grow renewable fuels over time. I recently announced increased protections for the nation's 2 million agricultural workers and their families. Every year, thousands of preventable pesticide exposure incidents cause sick days, lost wages, and medical bills. We can do better. The EPA's update reflects extensive stakeholder involvement from the agriculture community, industry, and federal and state partners. These provisions will help ensure that farm workers nationwide receive annual safety training, prohibit children from handling agricultural pesticides, and provide workers with the tools needed to protect themselves and their families from pesticide exposures. Again, thank you. I am happy and I'm honored to be here to answer your questions.
Well, thank you, ma'am. The chair would remind members that they'll be recognized for questioning in the order of seniority for members who were here at the start of the hearing. After that, members will be recognized in the order of arrival, and I appreciate members' understanding. So with that, I recognize myself for 5 minutes. Again, thank you for being here. With the Sixth Circuit's ruling on the Clean Water Plan, the Supreme Court's ruling on the Clean Power Plan, it's difficult to say for those of us in West Texas, legitimate concern that given that both of those involve what we believe is an overreach by the agency going around congressional intent, going around the law, can you talk to us about efforts that your agency will make on the intervening 11 or so months that you'll be there to obey the Supreme Court and the Sixth Circuit? Will you commit to not trying to go around now the courts with other ways to get at what you're trying to get done?
Mr. Chairman, EPA is actually trying to do what Congress told us to do with the authorities we have, and we feel confident that both of those rules will be seen as an appropriate and proper and necessary application of the law. If you look at the Clean Water Rule, the reason we did it was to try to clarify confusion that the Supreme Court actually raised and created in a couple of their decisions since the beginning of the last decade. On the Clean Power Plan, it is a pause in terms of the implementation and enforcement of the Clean Power Plan, but the rule is still in effect, and it will add some time to resolve those issues through the courts, but we feel very confident that it is going to be borne out to be a legal, lawful, and necessary law. Right.
Not unexpected for you to take that position.
But thank you for listening.
It shouldn't be unexpected.
I appreciate it.
You know, we've got some 31 lawsuits, attorneys generals across the country, farmers and ranchers, those who've tried to look at it, disagree. What I asked, though, was what will you do now while those rules or regulations are stayed from implementation? Do we need to restrict your funding in the appropriations bill to say no monies will be spent on backdoor implementation of either the Clean Water Plan or the Clean Power Plan?
Actually, what we're trying to do, sir, is make sure that the guidance that's currently in place in the Clean Water Rule that was issued in 2008 is implemented as well as we can. We are certainly going to respect the decisions of the court, but as I think we have heard, there is a lot of confusion, there's a lot of differences in those decisions. So we are working with the Army Corps of Engineers to make sure that we're implementing what's currently in place as best we can, try to avoid some of those confusions while we hope to bring additional clarity when the Clean Water Rule makes its way through the courts. On the Clean Power Plan, we will still continue to work with states that on a voluntary basis want to move forward with us and will continue to provide tools and outreach. But we clearly understand that the courts will be winding through the process of looking at that rule. The issue yesterday meant it's going to take a little longer for that to happen. We will respect that, but in the meantime, we're going to continue to address greenhouse gases with the authorities under the Clean Air Act that are available to us today.
Okay. Clearly, there's a pretty sizable difference of agreement that the authorities that you used to issue those rules were an overreach, and so I'm a little troubled by that. Can you talk to us about my comments about the input that you take from USDA with respect to pesticides and the work that you're doing there? Are you ignoring USDA? I'll give you a softball because I suspect you'll say no, but can you help us understand that you do, in fact, value the expertise and the long-standing trust that farmers and ranchers have with USDA in this arena and the distrust that's been created with EPA over the other things that are going on? You can't just separate the issues from in a vacuum. It's not siloed up. So our farmers and ranchers feel under attack. So talk to us about your respect for the USDA and their opinions on pesticides.
Well, sir, I work very closely with Secretary Vilsack, and my staff work very closely with USDA. We have great respect for that agency, the scientific expertise they bring, and their full knowledge of the agriculture community. There are laws that require us, even before we propose rules, to consult with USDA, and we do that. And then we work very closely with them in the interagency process to resolve differences. So I think we have a close collaborative relationship. At times we may disagree, but it's usually about what the law requires us to do. And there's good discussion, and we always try to understand the science together and make the appropriate decisions.
All right, thank you, ma'am. I yield back. Ranking Member, 5 minutes.
Well, thank you, Mr. Chairman. I want to focus on this clean power plant a little bit too. So we're kind of caught between a situation up in my district. The rural electrics get their power from North Dakota.
Mm-hmm. Yes.
But, you know, obviously we're in Minnesota. Well, Minnesota is apparently working with you guys on whatever they're up to. And I think North Dakota is one of those that sued you.
Mm-hmm.
So when you say you're going to work with states, does that mean you're going to work with Minnesota and continue to develop a plan with Minnesota while this is going on?
Well, we'll continue to work with them on a voluntary basis, but nothing will be implemented while the stay is in place. So if Minnesota wants help and tools, we would always work with every state that does that. But in terms of actual enforcement of anything, it is clearly on hold until it resolves itself through the courts.
Well, you know, one of our concerns, you know, there was apparently a 2014 proposal, and then it was finalized. And in North Dakota, you went from 11% to 45%, the biggest increase of any state. Well, you know, our REA-owned cooperative out there in North Dakota, those plants, you know, they did some updates back in 2005 or something and put in 426, or put in some improvements in their firewalls and so forth. And then you determined, the EPA determined that that was a major overhaul or whatever it was. So you forced them to go under some new program to put in scrubbers and a whole bunch of other stuff. They sued you. The end result of that was they spent $426 million. And my real question is, what that did is it dropped the equity in that co-op from 24% down to 12%. Are you aware of that?
Not the specific instance in which you're referring, sir.
And so they had signed an agreement with the RUS to get financing for this $426 million that you forced them to do. And it says that they can't go below 10% equity in that co-op. Well, they're down to 12 now. And if this is implemented, they will be down to 5%. So they're going to be in violation of the situation with the USDA. Are you aware of that?
Well, sir, if you're referring to the application of the Clean Power Plan, is that what we're talking about here? I know that you were referring to some of the regional haze decisions.
They borrowed money to comply with your other
Right.
situation. And in that, in order to get that money, they had to agree not to go below 10%.
Yeah.
So now, if you implement what the Clean Power Plan says, you're going to force them way below 10%. They don't have the money to do this anymore. You've already taken all their money, and there's no other way in Minnesota. They won't let them build a power plant. So the only thing we can do is get it from Canada. You know, if you go ahead and complete this, you know, so we're kind of stuck in this whole thing, and, you know, I was going to ask you today to delay this, to give us maybe 10 years to try to comply with this so we don't go bankrupt. But now with this stay, and I don't know where we're at anymore, but I mean, somehow or another, we need more time to...
Well, sir, we're more than happy to work with the state, and in fact, we have been out there. One of the things we did was extensive outreach on this, and there was concern in some states about whether or not they would internally in that state be able to make things work. We added huge amounts of flexibility in this, and we also engaged USDA, the Rural Utility Service, to work with us and with the rural co-ops. We understand that they have unique challenges, and we are not not going to leave them behind. They deal with some of the poorest communities that cannot afford to have energy increases.
That's exactly
And
correct.
so there are a number of programs that we're bringing to bear, as well as flexibilities that will not require every facility to make investments.
Well, for whatever reason, they seem to think that you're not going to have flexibility and not listen to them. I don't know why, and it's I think some of this power from these plants goes to North Dakota, but the majority goes to Minnesota, and we're kind of stuck in this whole thing. I'm glad to hear that you're willing to work with them, but that's not what they've heard. And after they spent that $426 million,
Yeah.
then you went after them on Hayes, and we were able to get that stopped. That would have been another thing that would have bankrupted them. So they just feel like they're in the middle of a whole deal and they're not listened to. So if you
Well,
would,
I'm happy to personally engage as well. I've been
I'll send
meeting
them
with
over
the
to your
rural
office and
electric
you can visit
co-op,
with them.
so, okay, sir.
all right, thank you.
Yep.
Gentleman yields back. Mr. King, 5 minutes.
Thank you, Mr. Chairman. Ms. McCarthy, I'm over here. And I appreciate your testimony and your service here. And a good number of things pop up in our minds that are come to our attention. I'm just looking at a few headlines here. Sixth Circuit puts controversial waters of the United States, the WOTUS rule, on hold. There's another article that addresses the Clean Air Act on hold. And as I'm watching this, it seems as though the agency has been pushing back against especially our farmer producers and our people that care about their value of their productive real estate. I just had a couple of phrases here that I've seen emerge from the EPA over the years, and I wanted to start with this. Water is hydrologically connected to. You're familiar with that phrase, and you're also familiar with the phrase significant nexus.
Yes.
Now, would you have a judgment on which one of those is the most ambiguous?
Well, the Clean Water Rule actually tries to provide clarity to both of those. The ambiguity arose when the Supreme Court actually raised these issues and suggested that EPA needed to resolve these. That's what the Clean Water Rule is all about.
And of course, I'm about clarity, of course, too. And then, so with regard to clarity, with the renewable fuel standard, you've taken a position in past years, back in about 2012 or 13, that we had short grain supplies and high grain prices. Therefore, you rolled back the directive on the RFS, and I'll just focus particularly on corn-based ethanol for simplicity's sake here, and made that judgment administratively, even though the statute required that those gallons be more. I notice now that we have high volume oversupply of grain and low prices that have dropped about a little more than half since that period of time. And I don't notice that the same logic is applied when it comes time to adjust the RFS for current conditions. So if it was a good idea to lower the RFS requirement for corn-based ethanol back when grain supplies were short and prices were high, why wouldn't it also be a good idea to raise it at least up to the statutory standard when grain prices are low and supplies are high?
So the renewable fuel standards that we came out with provide us an opportunity to get back on track as well as provide steady growth. The numbers that you're looking at in here is our assessment of what we can achieve attempting full bore to get to the statutory levels, but recognizing that leaps like this in these shorter time frame is not possible. So we want to achieve those statutory levels. We understand that's what Congress intended, but there is a growth that we need to recognize and factors that impact that we had to take into
You're talking about production capacity. You're talking about...
No, I'm not talking about production capacity.
Then what are you addressing?
I am addressing the ability for us to be able to get that fuel into the system.
And that's the blend wall.
That is correct.
And do you believe you have the administrative authority to abolish the blend wall?
Well, these numbers actually push through the blend wall because we understand that we need to do that to continue investments in infrastructure that will be necessary to get to the
You believe they have the
statutory
administrative authority to do that, to abolish the blend wall?
I believe we're doing everything that the law says, which is to get to these levels as quickly as possible, but you have to think of factors like how reasonable it is to achieve these within this certain period.
Have you, what about going to E15?
Yes.
Do you have the authority to do that?
We actually approved E15 in use of specific vehicles.
Year-round?
Mostly the modern vehicles we have.
Year-round?
Yes.
So we're past the E15 blend wall year-round. There's no vapor pressure requirement that restricts it any longer
There is
today?
a vapor pressure requirement. Yes, there is. But we approve the use in the vehicles, and it can be used. There are certain places where,
Okay, I'm addressing, practically speaking, I think I should have prefaced my question with that. Then also, with regard to the testing of fuels, my information is that EPA relied on a Chevron consultant to design the test fuels. Are you familiar with that?
No, sir.
Okay. I'm going to pose some of these questions to you in a written form so you have an opportunity to digest them and answer them in a way that's not a high-test area in the hearing here. I have a stack of questions I'd ask that you respond to with regard to testing requirements and compliance with the RFS. I'd ask you one final question. If you were the administrator of the EPA at the time that the RFS expires, sunsets, would you believe that you have the administrative authority to extend it beyond its sunset?
I'm not aware that the RFS sunsets, sir. What are we referring to?
Well, I'll put that in my question to you, too, the specific language that's in the statute.
Okay.
And so that'll all come to you, and we'll look forward to working with you.
I will, too, as well.
Thank you very much.
sir.
Now yield back.
Gentleman's time is yield back. Mr. Costa, 5 minutes.
Thank you very much, Mr. Chairman. I want to thank the administrator for being here this morning and your efforts to help us solve problems. I want to continue the conversation for a moment on the renewable fuel standards. Obviously, there's a diversity of opinion as it relates to this committee and members of the Congress on how it's applied and implemented. But can you explain the process that DEP will be taking to ensure that the 2017 rules are not delayed the way the 2014 rules were?
I can, sir. One of the things we made sure was to already propose a 2017 standard for biodiesel so that we could make sure to keep on track. And we have every interest now that we're on track to stay that way.
For those of us who believe in alternative fuels and renewable fuels, but think that cellulosic fuels are really the next generation of this development, can you explain the update on the Inspector General's investigation regarding climate impacts on the renewable fuel standards as to using food to produce fuel is the most effective way to do that, and whether that doesn't in fact create more pollution issues?
Well, I know that there's been a number of looks at this issue and investigations, but my job as EPA administrator is to implement the law that's been given to me.
Which you said is probably the most difficult
It is a
law
very
you have to
difficult
implement.
statute, yes. But it is very clear that cellulosic fuels have not progressed anywhere near what Congress anticipated, which is one of the reasons why those statutory levels are so difficult to meet.
Well, I want to move on to some local issues. As you know, California is a very diversified state as it relates to its agricultural production. The Environmental Protection Agency recently issued a statement on a risk report indicating that citrus and cotton honey contained higher levels of neonicotinoids than other honey, which would be at risk to pollinators. Now, because of the diversification of our crops, clearly we're sensitive. We grow a lot of almonds in California. I think we gave you some. I'm an almond grower myself. It does require bees, and we're sensitive to the pollination issues, and therefore the impacts of bee deaths and colony collapses. But why single out two commodities that don't require bees, at least in my state, that in fact we go out of our way to accommodate bees because a lot of the proximity of these crops are nearby each other. And in fact, recent reports have indicated that colonies have propagated, and they're at higher levels now than the decline we experienced a few years ago.
Well, Congressman, we've been to your area of the country before together, and I understand how hard the almond growers actually work, not just to address the pesticide issues, but certainly to conserve water, and I appreciate very much all that work. We're happy to work more closely with you on neonicotinoids. The science is difficult, but it is growing, and it is getting more robust. We think we're following the science in our decisions, and if there are issues
but we're
that
going
we
to
need to
need
resolve,
more of
we'll
your
be happy to
focus
do
on
that.
this. The chairman and I last night were in a conversation with some orange growers who are dealing with citrus screening.
Yes.
And they really think that they're being singled out, and because of the way in which the Environmental Protection Agency has approached this. And I will provide you more information to follow up. I want to, before my time expires, go to the larger issue that affects all of American agriculture, and that's the application of pesticides and herbicides and EPA's registration process.
Yes.
For most of us farmers, we live on our farms. The application of pesticides and herbicides is made with very cautious and cost-effective evaluations. We're concerned about the health impacts. We're concerned about the cost economic impacts. You're required to reevaluate your process on regulations or registrations every 10 years. But it seems a recent announcement portended for the adoption of a precautionary principle. Can you comment on your precautionary principle? And do you believe that zero risk is possible when using application of herbicides and pesticides?
Sir, we do not utilize the precautionary principle. Our decisions are based on the law, which is based on risk.
Do you believe zero risk is obtainable?
It is possible with some, but that's not the way in which our laws require us to look at this, and we do not utilize that as the...
There have been court decisions, and my time is about to expire, where various applications of these pesticides and herbicides have been brought to the courts, and in some cases, we believe EPA has refused to defend its scientific decisions on the challenges of these courts. This is very serious. You're supposed to be the clearinghouse.
Yeah. Well, we vigorously defend our decisions in court. We do that because we believe we did the right decision based on science and the law. There are times when even a vigorous defense does not carry the day in the court, and we have to abide by those decisions. But in no way are we backing off of our decisions in the way in which we have always made them, which is based on the law that exists, and we're continuing to apply that and vigorously defend it.
Thank you, Mr. Chairman, and I'll have more information to follow with the witness. Thank you.
Now I recognize Mr. Rogers of Alabama, 5 minutes.
Thank you, Mr. Chairman, and Administrator McCarthy, thank you for being here today. I'm sure it's not a surprise to you when I tell you that many of my farmer constituents are very worried and upset over the number of regulations coming out of the EPA that negatively impact them. Do you intend, first of all, are you cognizant that there are those concerns by American farmers, and is there anything that you're planning to do to address that perspective that they have of your agency and its regulations?
Well, yes, I am aware. There is a lot of work that we need to do to establish a stronger trust relationship between the agriculture community and EPA. I've been working hard for the last few years, trying to get out to farms, meeting with every farmer, rancher, and forester that wants to sit down. I'm trying to work through the issues and listen closely and learn.
Are there any fundamental changes that you think that you're going to be able to make, or that you plan to make, that would remedy or alleviate some of those concerns?
Well, implement the laws as effectively as I can. As I noted, we have a number of voluntary programs that we're initiating back and forth. We have new advisory groups being started. I think the most important thing we can do is listen to one another and try to identify the path forward that meets our shared goals, because we certainly share the goals of wanting to protect the environment.
Well, I agree. I think that listening is a good first step, but you've also got to be prepared to act.
Yes.
And it may mean act in a different way. But anyway, I'm glad you mentioned volunteer programs. I believe we need to encourage programs that provide farmers with the resources they need to work with states, and not the EPA, on water quality problems. Congress did not give the EPA regulatory authority over family farmers. I'm concerned that the EPA is moving away from voluntary programs that have verifiable results and instead intends to create burdensome regulations. Do you agree that voluntary programs are important and an effective way to help reduce pollution or is the EPA trying to expand its regulatory authority over non-point source pollution?
Absolutely, I agree that voluntary programs as well as technical support and funding support from the federal government is an essential way in which we need to move forward and work together, and that is the vast majority of our relationship.
Okay. Where in the Clean Act did Congress give the EPA authority to regulate sustainability of agriculture, non-production practices on farm fields? I don't see that precedent anywhere.
Under the Clean Air Act, is that what you said, sir? There is, I don't not know whether the word sustainability is written into any law. I think it was an outcome of understanding that we need to understand the life cycle and all of the challenges associated with clean air and other requirements that are being placed on our constituencies, including farmers, ranchers, and foresters. And it was an open dialogue to understand how our rules can enhance not just their health and our health, but their viability as a sector. I think that's what sustainability is intended to make sure, that we're thinking about this in a common sense, holistic way, not a narrow media by media approach.
I agree, but it didn't give the legal authority to the EPA. What I'm looking for is, do you see in that act the legal authority to regulate sustainability?
We do not regulate sustainability. We do regulate pollutants under the Clean Air Act, one of which are greenhouse gases. If that's what you're referring to, sir, that is because under the Clean Air Act, the Supreme Court clearly told us that we had to look at greenhouse gases as a potential pollutant, and if we found that they were an endangerment, then we had to take appropriate action. That's what we're actually doing.
That's the precedent I'm looking for. Could you have somebody on your staff get me a copy of that Supreme Court interpretation?
Absolutely.
I'd appreciate that. And finally, GAO released a legal decision that the EPA was violating publicity or propaganda and anti-lobbying provisions contained in previous appropriations bills.
Yeah.
And your agency, according to them, has been using social media for covert propaganda. What is your side of that?
Well, as you might guess, we don't agree. We do not believe that we have violated any provisions. The GAO looked at thousands of social media that we actually do every day, because that's how we do our outreach and education. That's all that they were. They found 2 instances that raised questions for them. We disagree with the decision, but we certainly are working with OMB to make sure that we have followed every one of their procedures and we do everything we need to do.
Thank you, ma'am. I yield back.
Thank you.
Chairman's time expired. Mr. Waltz, 5 minutes.
Well, thank you, Chairman, and thank you, Administrator, for being here with us today. And I appreciate the work that you've put on this. I appreciate the visits you've taken to farm country, and curious a little bit about what you're hearing out there. But I remain the optimist that I do think it's possible in this nation to produce food, to continue to feed, fuel, and clothe the world, at the same time addressing real-world issues of clean air, clean water, and environmental sustainability. And I think that's what we're all trying to get at. A statement that comes up often with my producers out there, and these are folks that are committed to this, they don't deny the science, they understand the importance of it, is regulatory humility. I think regulatory humility. Huh. Just a sense of kind of working with it, that there's a, I've used the term before, a bit of a bunker mentality about all these things keep coming down without asking us. And I think Mr. Rogers was getting at it, and I agree. I'm very proud of the work that this committee did, and many of our folks working on the last Farm Bill, on the conservation piece of it. That conservation title was lauded by many as being one of the strongest ever across the spectrum, from producers to environmental groups. And you kind of hinted at it or whatever, but are those working? Are those making a difference? Because my attitude on this is we're far better ahead if we can prevent a problem than dealing with it afterwards and getting into the courts and everything else that comes with that. Are some of those working? And if you could maybe pick out one that you think is the way to go?
Yeah, I think the conservation efforts are absolutely working, and you can see that in many locations. Do we need to do more? Absolutely. But that is the approach in which EPA certainly prefers and takes. And so I think if I wanted to highlight any, I think that it would be in the Great Lakes area. areas in which we are actively supporting conservation efforts and doing that in a way that will help us prevent pollution into the Great Lakes, which are causing these harmful algal blooms. There is a collaborative spirit. There is funding. There is technical resources provided to this. These are the kind of programs we need to have to move forward. And EPA is working every day with USDA and the NRCS to see how we could advance their mission as a way to advance our own. I do not need to duplicate it. I need to respect what they do and help support that and identify ways of appropriately expanding that in areas where we find there are challenges.
I think that story needs to get out there because I agree. This is about helping us reach a common goal, not telling us. And I think that telling us attitude, whether it's, you know, perceived reality is reality.
I know.
And a lot of people feel that way. And if I could, some of it comes from this. I just asked this statement. This is the one that's confusing on this. Two statements were made. I think your agency stated that 3 to 5, approximately, and not holding you to that, 3 to 5% more jurisdictional waters. But we were also told, and the red line for me was, if you didn't need a permit before, you won't need one now. You can't have both those statements, can you?
Yeah, you actually can, and let me just try to explain it. The increase in jurisdictional water determinations is because the rule is much more specific about what is jurisdictional and what is not, so there is not significant amount of time wasted asking in areas where there is no jurisdiction or where we well know that from our history there is a direct hydrologic connection that is significant enough to warrant protection. But in terms of the agriculture community, there is no added permit burden.
Unequivocally, I can go back to every one of my producers and say, the way you're doing things now, if you were up to standards, nothing changes.
That's correct. We've actually expanded clarity on some of the exemptions and exclusions so that we can make that clearer and clearer as time goes on.
Thank you. And I'm going to segue again just a little bit because we mentioned it, collaboration with USDA. What conversations happen on RFS, if you could, in dealing with
USDA?
Yes.
Oh, lots at every level.
Extensive all the way through the process.
It is, both in how we look at feedstocks, how we look at those life cycle impacts, to the numbers we should put in, to what can be produced, what can be consumed, what can USDA do like their advancing of blender pumps, what does EPA need to do to make sure those blenders can actually go out there and all those blends be utilized. We work pretty constantly on RFS together.
And I appreciate that. And I think the more, and I know you do it to the best of your ability, is to get out there and make those statements, show that collaboration. And again, it's coming back to that regulatory humility that we're in this together. We've got common goals.
That is a term I will take to heart as I leave here.
Thank you,
so
ma'am.
much.
I yield back.
Gentleman yields back. Mr. Thompson, 5 minutes.
Thank you, Chairman. I haven't seen a lot of regulatory humility, at least since I've been here. More like, unfortunately, just my opinion, regulatory arrogance. Administrator, thank you for being here. I appreciate you coming, sitting in the seat, taking tough questions and your responses. I want to follow up on Mr. Rogers' question, your response to the last question on this side, regarding the use of social media.
Yes.
I found it interesting. So since the EPA disagrees with the regulations that they've been confronted with, and basically they disagree with the regulators that were responsible for that were wrong in your interpretation, so you're not changing your practices. So my question is, can my farmers do the same thing? Can they? I mean, they disagree with the EPA where there's a question of authority as a basis of legislative language, as a basis of a now growing trend and series numbers of Supreme Court rulings. Do they get the same pass that it seems like your agency is choosing to do when your feet is held to the fire under regulations?
We are not doing anything that would skirt the decision that GAO made, their interpretation of the law. Our Office of General Counsel believes that they are incorrect in their interpretation. Nevertheless, we have
so what you're saying, okay, we gave you the
nevertheless,
strategy. If my
we're actually
farmers get an
working with
army
OMB on what the appropriate response is to that. So they do have their opinion. We will respond appropriately to it, but we still have a right to say that legally we don't think they were correct.
Sounds like my farmers
that's all.
would be better off if they had an army of government-paid attorneys. So That's not my question, though. That just happened to come up. Many believe that the Chesapeake Bay TMDL represents a massive seizure of state government power by your agency and will serve as a blueprint for regulating watersheds around the nation. Now, through its standards, controls, and rigid rules, the agency is setting the stage for taking over many, if not all, land use decisions nationally. Really a private property grab. In effect, becoming a national zoning board. The TMDL is already having devastating impacts on farmers in defending the TMDL. Currently on appeal to the Supreme Court, your agency has defended it, saying that the states are developing their own standards. Now, let me read to you what one state in the Chesapeake Bay watershed, Delaware, not my state, wrote of this voluntary, quote, voluntary, unquote, procedure in its watershed improvement plans. The state wrote that if the program fails to meet standards acceptable to the agency, then quote, the EPA has identified a set of potential consequences to impose. These consequences range from the EPA taking over responsibility for developing the plans to increasing their regulatory oversight and extending their regulatory authority to additional sources of pollution, end quote. In short, this quote's articulating that if each state's watershed improvement plan doesn't meet EPA standards, EPA can then force its own plan on the states along with punitive actions. My question is, with all of this authority, in what sense was there anything voluntary about this process? Your agency directly and indirectly told states that it wanted what it wanted, made it clear that there would be consequences to not delivering on what it wanted, the standards and the plans it expected. How is that voluntary?
Well, sir, let me try to answer that question. The Chesapeake Bay TMDL was an opportunity for a number of states who share a common both environmental and economic interest in having a healthy Chesapeake Bay. That program allowed them the opportunity to actually meet compliance with reducing the standards necessary to get that healthy again
and
in their own way.
As the chairman of the subcommittee that includes watersheds, I love the Chesapeake, and we're achieving that, but we're just I'm talking about the overreach here.
But we have never actually had to intervene. There is great progress being made through the efforts that each state has been taking. They do care about the Chesapeake and they're making progress. The question was asked, what if people don't do anything? Well, there is no question that TMDLs are a regulatory requirement. And so there are things that we could do if there isn't continued progress as anticipated. We have never had to use that.
Well, ma'am, I would refer you to the transcripts of when our subcommittee on conservation, energy, watersheds met, and your individual in the Philadelphia office clearly said this was not a regulation because it was voluntary. And then, I mean, it was some of the most confusing testimony we ever heard because it's being aggressively implemented as a regulatory action, yet, you know, clearly the way it was, it just is overreached to the 10th degree, and I appreciate your response, but the uncertainty's still there on there.
Chairman yields back. Ms. Fudge, 5 minutes.
Thank you very much, Mr. Chairman, and thank you, Administrator McCarthy, for being here today. I'm going to go strictly local today.
Okay.
I live on the banks of Lake Erie in Ohio. Lake Erie provides drinking water to millions. It supports thousands of jobs and contributes over $1 billion to our local economies. Yet harmful algal blooms are only intensifying each year, and we are persistently faced with the threat of open dumping that we believe to be harmful sediment into open Lake Erie. And we believe that it is an adverse decision by the Army Corps. Despite the great progress made in reversing past environmental damage, we find ourselves locked in an ongoing battle over this seemingly non-controversial issue. The EPA plays a critical role in protecting drinking water and the health of our lakes. What are you and your administration doing to ensure the continued growth and recovery of Lake Erie?
Well, I am familiar with the issue you raised with the Army Corps, and I'm hoping my understanding is correct that the Corps is working with the state and all the constituents to identify ways to stop dredge disposal in Western Lake Erie. But as you also know, we are working very hard through our Great Lakes Initiative to actually understand the science in Western Lake Erie, understand where the sources of the nutrients that are contributing to those algal blooms are, and we're actually supporting it with $11 million from EPA's funds to try to help those upstream farms and agriculture to find ways of taking conservation efforts and other voluntary actions that will begin to make a real dent in the challenge we're facing in Western Lake Erie.
Well, thank you, but I certainly hope that you would check further, because it's my understanding at this point that even though the court has decided that it is not appropriate for them to dump the sediment into the open lake, the Army Corps has decided that they are not going to comply with the court order. And so I think it's important that we move expeditiously to determine why, and why they have not requested the resources that are necessary to contain the sediment.
Okay.
So I would ask that you would check that further.
I'm happy to do that.
Thank you. The growth of urban agriculture is vital to solving the issue of food deserts in many low-income neighborhoods, many of the ones that I serve. In post-industrial cities such as Cleveland, historical contaminants in the soil can stall the growth of these programs. What role is EPA playing in ensuring urban land is safe for farming?
Well, one of the efforts that I mentioned early in my oral testimony was the local food, local places effort, which I think adds enormous opportunities for urban communities that are literally food deserts, and to open up and do planning and to bring federal resources to the table that is really focused on food first. You know, instead of as an afterthought. There is a great change that's happening, I think, in urban areas, understanding the need for locally grown food and the value that that can bring not only for the health but the vitality of the community. So I would really encourage, you know, anybody's active participation in the local food, local places initiative, because that can bring resources, brownfield redevelopment resources, to the table that would address the soil contamination issues you're identifying. Many of those turn into vital places for communities to gather and grow food. So do not give up in an urban area on the ability to grow food and to make that part of the community revitalization efforts that everybody is looking for.
Thank you. And lastly, seasonal agricultural runoff is a factor to the growing problem, of course, of algal blooms on the lake. What steps is EPA taking to address the lingering pollutants still contaminating river and stream sediment?
Well, a couple of things is we've mentioned the Great Lakes Initiative, but I think most importantly that is our collaboration with USDA, as well as our looking at areas of concern in the Great Lakes where we know we have significant sediment and water contamination. So it has to be a combination of all of those efforts. It's not just about stopping what might continue to be coming in, but it's looking at those hot spots, if you will, so that we can continue to make progress, which we have made tremendous progress on, but that's one of the 3 areas that the Great Lakes Initiative is focusing on in the coming years.
Thank you very much. Mr. Chairman, I yield back.
Gentlelady yields back. Mr. Nagelbauer, 5 minutes.
Thank you, Chairman, and thank you for holding this hearing. Administrator McCarthy, in my area, the prevalence of technology out to our producers. Can you give the committee any update on where things stand at EPA and what is the continued holdup by EPA?
Is this the dicamba? Yeah, in early 2016, we actually proposed for public comment a regulatory decision on dicamba for the exact reasons you're talking about. We know that there's significant interest in this. There has been tremendous work on the science side. After the comment period, we're going to review those comments and continue how the agency can move to a final so that we can get this done and over the finish line.
Yeah, could you kind of give me some encouraging timeline here so that folks could look forward to?
Sir, we're working as hard as we can. We'll get it done as soon as we can. If you'd like me to reach back to you after the hearing, I can get more details on where we might be.
That would be helpful.
All right.
Enlist Duo also ran into some trouble last fall with EPA's decision to request that the court remand registration back to EPA for further review. This is only the first time ever that EPA has attempted to vacate a pesticide registration through a court action. Currently, under FIFRA, and EPA is required to comply with a number of procedural safeguards before a pesticide registration can be canceled, which it has failed to do.
What was the agency's rationale for taking such an unusual step of asking the court to require EPA to review the registration of a product so recently approved for use, and why is the agency now trying to use the courts as a means of regulation?
Actually, we weren't really trying to do that, sir. The 2,4-D decision that we made on Liz Duo was a controversial one, as you may know, but we followed the science and we followed the law. The awkward situation we found ourselves in is after the decision was made, while it was being challenged in court by those that disagreed with our registration, we identified information that the manufacturer, Dow themselves, had put out in other public venues that raised concern that we did not have the full science data to make the decision in the most solid way we could and actually address what might be synergistic effects. So instead of waiting for the court to tell us that we had failed in our science decision, we wanted an ability to take that back, to work with Dow, to get additional information, to address the issue, and to move it forward again, which is exactly what we're doing. We're actually working with Dow about what this science is that they put out in other venues, what data did they have, what data might we need to actually redo this decision in a way that we think will be legally solid and respectful of the full range of science.
Now, I think some of the question that you've not followed the law procedurally on this. Do you believe you have?
We do, and we think we actually did it in a way that will get to a decision much more quickly. The challenge is that Dow did not give us the full range of data, and we found it in another venue that was publicly available. So when we found that out, we worked with Dow, and we have a system to move forward to respect the full range of science that we're required to look at.
I'm always interested in timelines, and you said quickly, and I've learned it quickly in West Texas and quickly in Washington, D.C. don't necessarily have the same meeting.
We actually, I think, I will double check when I go back, but I'm pretty sure that we've already received a lot of the information that we've asked Dow to do on 2,4-D, so we don't think that there's going to be a significant delay in the reconsideration of this and moving it forward.
Well, on those two issues, Administrator, if you could maybe have your folks kind of give me a timeline so that I can report back to the folks, Cotton folks.
I'm more than happy to do that.
With that, Chairman, I yield back.
Gentleman yields back. Mr. Aguilar for 5 minutes.
Thank you, Mr. Chairman. Thank you, Administrator, for being here. I, too, will ask a little bit of a local question, if you don't mind. I represent the community of San Bernardino that has been in the news recently, obviously, for some terrible acts. While climate change affects us all, this is incredibly personal for me and the community that I represent. I can recall smog days growing up where we weren't allowed outside because of the air quality levels. And this is particularly important because our community sits at the base of a mountain range that captures smog and air quality issues that mostly generate from out of the area and blow in with the trade winds. I believe the national ambient air quality standards are a great benchmark for communities to strive for in order to improve pollution levels. However, San Bernardino has been in the unique predicament due to the fact that the smog from Los Angeles also contributes to the pollution in our region. Are there resources and tools that the EPA can offer San Bernardino County as it continues to work toward a management plan to improve air quality? If not, does the EPA plan to provide any sort of regulatory relief, or as Mr. Walls coined, regulatory humility for counties and areas that are not in compliance?
Well, let me begin by expressing my sympathies to you and to those in your community. The National Ambient Air Quality Standards rightfully established by law health standards that we all strive for. We well recognize that California is challenged in meeting those, and there have been some unique tools developed that we have had the authority to manage, that have provided direct assistance for new technologies and other efforts to support the state's aggressive effort at looking at these areas. There's also tools built into the law itself, so that if you have a difficult challenge, you can't meet it, provides additional time and opportunity to get that done. And part of the value of the state planning process and the really the aggressive and maybe aggressive isn't the word, but the collaborative process, the outreach that Region 9 does to its communities to try to work with them hand in hand to address these challenges is really of great value. So I'm more than happy to make sure that folks come and sit down and see if there are particular issues of support that your community may need to build into a state plan that would help you achieve these standards quickly. But I want to just reinforce the fact that the law does not, nor does EPA, ever require more than can be done. You know, we know that there are transport challenges and there are unique geographic challenges that California faces. So while we hope to continue to make progress, we understand that that will take time, and it will take a collaboration, and it will take new technologies to advance this. And whatever is coming in from other communities is going to have to be a collaborative, multi-community effort.
Sure, we just want to make sure that that's part of the discussion, and there has been a discussion and some flexibility in the past. We just want to make sure
we
that
will
those
keep that up.
That those standards are still in place. And if we could follow up with your staff to have
That'd be great.
A little bit of a deeper dive, that would be very helpful to my office. With that, I'll yield back, Mr. Chairman. Thank you.
Thank you, Mr. Aguirre. Gentleman yields back. Mr. Gibbs, 5 minutes.
Thank you, Mr. Chairman. Administrator, first, thank you for being here. I would start out for a clarification. My colleague, Ms. Fudge from Ohio, on the Lake Erie issue, it's two separate issues. The algae bloom issue and the Western Lake Basin. You're correct.
Yes.
They do dredge and dispose in the lake. The issue was unclear on is the Cleveland Port issue. The Cleveland Port issue is a dredging issue. It's about PCBs. In the state of Ohio, and the Ohio EPA has sued the Army Corps of Engineers over this issue. And it's interesting, your agency has been silent on this issue. So I want to bring that to your attention. Okay? And that's two separate issues there in Lake Erie. I do want to talk about, in your testimony, you talk about Waters of the United States rule. I agree with you on one aspect of it. Farmers do want clean water and drink clean water, so we agree on that. But my concern is, and it's evident by what's happened, within 24 hours when you filed the final rule in the Federal Register, nearly 30 states filed a lawsuit. Now I think it's up to over 32 states, around 32 states have filed a lawsuit, and numerous organizations and entities are against this. And so it's clear that there's concern about this, and obviously the states erodes their states' rights. And I think it needs to be made clear when the Clean Water Act was passed. I think the intent of Congress was supposed to be a partnership between the feds and the states, where the states would implement and enforce the Clean Water Act under the guidance of the EPA. Now, you made a statement here to one of the questions, answers one of the questions. You insinuated that if the rule had to be extended to include more waters, so those waters are regulated. You were insinuating that the states aren't regulating waters. I, as a farmer, can't go out and dump my hog manure in any stream that's not WOTUS, Waters of the United States. I'd be breaking the law. So I want to make it clear to the public that waters that aren't under the authority of the federal government are being regulated in that partnership agreement. And you agree with that, correct?
In many states.
But you do insinuate that. And so
well, it wasn't intended, sir. We're partners with the state in this effort.
Now, I also have a concern that what this is going to happen is it's going to require more permits, more Army Corps of Engineers, and inefficiencies. But I think we risk the potential to go backwards in the progress we've made since 1972 in water quality and protecting the environment in this country. Because when you add on so much more red tape and bureaucracy, people at some point throw their hands up in the air and say, well, I might not necessarily gone the extra route I would have done. I'm going to do just enough to get by, but I'm not going to do it because this is just it's just a bunch of nonsense and a bunch of red tape, and the bureaucrats go crazy on them, and so I want you to be aware of that fact, that this rule can make us actually go backwards, and we're eroding that partnership agreement that was set up in 1972 with the states, and obviously when over 30 states have sued you over this, you ought to pay attention to that. Now I want to also get to the part about the GAO Inspector General report. You know, they came out and said that the EPA used covert propaganda to bias and skew the comment period. Now, I know some of the people are poo-pooing this is not a big deal. I think this is a big deal because it goes to the integrity of the whole comment period process. I mean, the process is there so the stakeholders can put in what they need to, you know, comments, and it's up to the regulators to use their due diligence to figure out what's to make the best rule that works and protects the environment in this case. And here you got the Inspector General, GAO, come out and say you broke the law, you went to, it goes to the integrity of the system. So my question is, what's the EPA done to initiate the reporting violation under the Anti-Deficiency Act, a copy to the Comptroller General and the Congress and the President as required by the Anti-Deficiency Act? If you reported to us, what resources were expended on these illegal activities, both monetary and fuel time equivalents? What internal action has been taken in your office to make sure that this doesn't happen again? And has any internal action been taken to punish people that broke the law in this case? And so I'll let you answer those questions.
I think so. You know, I don't think that folks in the agency broke the law, but let me answer your question directly. We are working with OMB. There is a draft letter at OMB to make sure that we are following our obligations under the law to respond appropriately to GAO. I think the word propaganda is always construed as something horrible. The propaganda that they were referring to was not that we lobbied Congress. It was not that we said.
No, you were lobbying people to lobby us.
No,
because you were trying to educate them
actually,
that this was what you guys want. You guys are actually proponents of this, and now you got all the state EPA suing you over it.
Issue was
Wake
that
up.
The propaganda issue was that we used a system that OMB approves under their guidelines, which was basically a general message saying, I really care about clean water. And GAO was worried that when other people retweeted that, they didn't identify it as an EPA message.
Did you use a system called Thunderclad that couldn't be traced back to the people putting it out? Is that true? Is that my understanding? Part of social media called Thunderclad, I believe.
That was the social media.
And that can't be traced back to the people putting it out. Is that true?
No, what happened is we put it out, other people retweeted it, and when they retweeted it, GAO thought that it wasn't their message, it was EPA's message, and we didn't properly identify it as such. That's what they said. But it was a general message, I like clean water. The other was a blog that had a hyperlink where we referenced a really cool program that an NGO was doing, and they were worried about that.
An oversight. The GAO said you broke the law.
But I don't want to minimize it, sir. We will pay attention to what GAO said, and we do have a letter in the process to meet all obligations. We just disagree that it was a problem.
Gentleman's time has expired. Ms. Adams, excuse me. Ms. Adams.
Thank you, Mr. Chair. Madam Administrator, thank you so much for being here. While many are concerned about federal overreach in environmental management, actions by the state of North Carolina resulted in tens of thousands of tons of coal ash spilling into the Dan River in 2013. The state refused to use its own authority to enforce proper maintenance and relocation of coal ash ponds at high risk of spilling into public drinking water. Administrator McCarthy, it's important that we together defend and uphold the EPA's final rule on the disposal of coal combustion residuals from electric utilities. EPA's final rule on coal ash disposal can only be enforced by states or by a citizen that sues a company or a state that violates the regulation. It is for this reason that I'm drafting legislation to strengthen protection and enforcement of rural water sources, which would provide rural communities across the nation with the same requirements that citizens in North Carolina now enjoy. Specifically, the bill would require coal ash pond owners and operators to be transparent in their surveying and monitoring of the quality of water in our communities. The bill mirrors laws that have already been passed by the North Carolina General Assembly. My question is, given the continuing threats of coal ash disposal, what is EPA doing to assess and prevent drinking water contamination and the risk of catastrophic collapse?
Well, as you know, we take this issue very seriously as well. Certainly, there's been disasters that we need to make sure don't get repeated. So as you know, we just recently finalized a coal ash rule. That looks at two things. One is the structural stability of those units so that we can make sure that they're stable and they're being properly inspected and if necessary, repaired. The second is to make sure that groundwater is protected and actually cleaned up. And that rule has requirements for both of those efforts. And we have information on the web so that people can see that see what's being done and what we've identified in terms of our assessment of those that structural integrity, so that information can be available to the surrounding communities.
Thank you. Will EPA provide technical assistance to low-income and minority communities so they are aware of and can understand the information about coal ash dumps that utilities are beginning to disclose?
Congresswoman, this is the first time I'm aware that you're contemplating this type of legislation. We're happy to work with you on language around that and talk about what authorities the agency might have to support this effort even in advance of that legislation moving forward.
All right, thank you. The Center for Public Integrity found that your Civil Rights Office has dismissed 9 out of every 10 claims by communities alleging environmental discrimination and have never issued a formal finding of a violation of a Title VI violation. Given this poor performance record of EPA's Office of Civil Rights, do you have any thoughts about why EPA hasn't ever made a finding of discrimination under this title?
Well, I think it's easy from that record to understand that the agency has faced challenges in dealing with our Title VI complaints. One of the things that I've done since coming here is to try to aggressively tackle that issue. We're really committed to building a model civil rights program, particularly how we handle these. In the last 2 years, we have new leadership in our office. We've developed a strategy to manage that docket of complaints more effectively. We just this fall released our external compliance strategic plan, a new civil rights toolkit. So we are doing what we need to do to get up to speed, but that doesn't mean we don't have a history that we need to acknowledge and use that history to inform how we can be a model agency moving forward. And we're trying very hard to make sure that we do that.
Well, I certainly hope it improves. It's not very impressive right now, but thank you very much for your comments. And Mr. Chair, I yield back.
Thank you.
Ms. Adams yields back. Mr. Austin Scott, 5 minutes.
Thank you, Mr. Chairman. Ma'am, thank you for being here. I want to go back real quickly to what Mr. Nagelbauer from Texas was talking about with the dicamba and the 2,4-D issue.
Yeah.
There's been several things that have been approved by the USDA for months. And farmers start planting cotton in his state in March. In my state, it's more in April. But it takes time to get the chemicals produced and through the distribution network and to the farm. And if y'all take much longer, quite honestly, they're not going to be available for us this year. And so I appreciate your commitment to help the farmer. I hope that we will see you act on these pending registrations sooner rather than later. And I think that's one of the breakdowns that we have between the government and the public and the farmer is that it seems that the people in the agencies have no idea when farmers even plant their crops and what the agencies are doing to the cost of those crops. And can you tell me what cotton's trading for? Do you know?
I can't, sir. No.
It's below the cost of production right now. And so are a lot of the other commodities. And so when you take an area like mine that produces a tremendous amount of cotton every year, and cotton is below the cost of production, you would typically look to another commodity. But they're also below the cost of production. And I appreciate your comment that you're trying to help the farmer and the farm, but the government's getting in the way of the farmer being able to survive through these tough economic times. And things like approving these chemicals sooner rather than later would at least help us determine what crop we can plant. And I want to go to the neonic issue right now, and I certainly understand
the value of pollinators. I mean, without bees, you'd lose the majority of the food in the world. But there's situations with the pollinator and the preliminary risk assessment, and specifically cotton, which I was talking about earlier, is a self-pollinating crop, and it doesn't require bees. So did the EPA take that into account as part of its assessment with pollinators, that cotton does not require bees for pollination?
I think I'll have to go back, sir. Are we talking about, which chemical are we talking about in particular?
The neonics as a whole, the whole class.
Oh, certainly. We certainly are. We are not making broad brush decisions on neonics. We're looking at each of them. And in fact, the decisions that we have been proposing have been very specific to look at being specific to the crop as well as the time of year, and what we can do to both protect the bee colonies as well as make sure that these are available when they're appropriately used.
I'll take that as a commitment that you'll continue to work with the industry.
We will,
and the
absolutely.
registrants, and I appreciate that. Are you familiar with the agency's proposed rule on greenhouse gas emissions and fuel efficiency standards for medium and heavy-duty engines and vehicles, Phase 2?
Yes.
It's would you agree also that Congress has excluded non-road vehicles that are used solely for competition from EPA regulatory reach?
Ooh. I believe that is the case, but I'm not as familiar with that as I am my standard rulemaking process, ongoing rulemaking process.
Fair enough. According to the EPA website, Congress did. It's one of the things.
I believe so.
We talk a lot about the things that we told you to do, but there are also things that we specifically tell the EPA that you do not have the authority to do. And one of those, I agree with what you said, that you don't have
I don't think so.
the authority to regulate competition vehicles. I'm concerned about the fact that in this 629 some odd page rule that's supposed to deal with greenhouse gas emissions for medium and heavy duty engines, that in the kind of the catch-all provision, that the rule has attempted to bring back in to regulation competition vehicles. And I agree with you 100% that you don't have the authority to do that, and so I appreciate you telling me that you.
Well, Mr. Scott, let me get back to you. I'm sure if that was part of the proposal, we've received a lot of comments on it. I'm happy to close the loop with you on it. We certainly have not finalized that rule. We're considering all the comments. But if you think that there was a disconnect, I'm happy to connect with you on it individually if you'd like.
I agree with you that Congress specifically said that you don't have the authority to regulate competition vehicles, and ma'am, I appreciate your time, and it's just kind of, it's very disconcerting as an American to see that in a 40,000 pages of rules and regs that we have an agency that would put something in a heavy-duty vehicle rule that deals with race cars.
Chairman's time has expired. Ms. Plaskett, 5 minutes.
Thank you, Mr. Chair. Good morning, Administrator McCarthy. I wanted to talk with you about the Virgin Islands is very, very much has a relationship with EPA because of our complete surrounding by water, and our land and our sea are our greatest resource, both for our farmers as well as for all of the industries that we take up. Several years ago, though, the Virgin Islands was devastated by the closure of our oil refinery. And that oil refinery meant that we lost millions, hundreds of millions of dollars in revenue, and hundreds of millions more in lost economic activity. Just recently, however, the facility was in a bankruptcy sale, and a private equity firm has elected to purchase it. And that may lead to the restoration of more activity on the island. However, there's a concern that we have with regard to the EPA and the potential of the EPA asking that the government of the Virgin Islands be a co-permittee on its RCRA, its Resource Conservation and Recovery Act permit. These permits were originally put out for Hovensa in 1999. And at no time during the renewals of those permits had the Virgin Islands government be included in it. The Virgin Islands government doesn't even make up 5% of the land in this area. We were, by an act of Congress, given title to the submerged lands to be entrusted for the citizens, and at no time has the Virgin Islands ever elected to operate a refinery, use the facility, but is really holding those submerged lands in trustee. Now, I understand that Hovensa is no longer the owner, but there's real concern that we have with Region 2 taking the position that the Virgin Islands government must be included as a co-permittee. It's our belief that Region 2's position is based on an overly expansive interpretation of RCRA and is an unjustified departure from its long-standing agency policy. I'm sure my colleagues here would see that this could be a problem if this takes precedent, in that you have your state and local governments, which may, by EPA, be forced to become a co-permittee on hazardous waste areas back home in their own regions. And so we have really been reaching out to EPA, and particularly in Region 2, to see how we can resolve this. And I'm not sure if you were aware of this. I wanted to bring this to your attention. Are you aware of any instance that EPA has forced a state or territory to become a RCRA permit, be on a RCRA permit based on its owning a small portion, 5–10% of the land that a facility has?
I do not know all the uniquenesses of this situation, but it is certainly my understanding that the region has taken a legal position that because the part of the land in which the facility is located is U.S. Virgin Island land, that there is a connection and that they should have been on the permit. Now, having just learned this, I can't tell you whether we've done this before, whether there's unique trust responsibilities that we're not looking at. So I'm more than willing to go back and look at the region, but it is very clear that RCRA has brought in communities, municipalities, and states into the RCRA responsibility system, even though they are innocent landholders, and that's respected in the process, but they become part of the permit and the process moving forward.
Well, it seems to me to be unclear why you would have an original permit in 1999, renewals of that same permit when another owner was operating the facility. Our ownership has not expanded at any point in this. We've always had the same 5% of those submerged lands that this body, Congress, put on the government of the Virgin Islands to hold in trust for its citizens. And now, seemingly, when there is no title holder anymore, because Hovensa has gone into bankruptcy, the EPA Region 2 has decided that the Virgin Islands government must take on responsibility for hazardous waste and activities that the facility owners were operating in. I mean, what more can a territory take on? What more can a government that's already bankrupt take on its back? Now you have the owner, Hovensa, leaving, purchasing by another entity, and the federal government, the agency, is forcing us to take responsibility, possibly liability, for hazardous activity that a private owner had on 95% of that land. It just seems an expansion, because there isn't a private owner anymore to hold a responsibility, to put it on the backs of a local government that can do nothing but, say, please don't do this to us.
Well, this seems like a very unique circumstance. I would suggest that we follow up with this conversation, and it is not a decision that, or an interpretation that I've been engaged in, so why don't we do that?
I would appreciate that so very much.
Alrighty.
Thank you very much.
Sure.
Thank you, Mr. Chairman.
The gentlelady's time has expired. Now recognize the gentleman from Arkansas, Mr. Crawford, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Administrator McCarthy. I know this has been addressed to some extent, but I don't think it's been, I think we can take a little deeper dive on this issue with the grassroots campaign effort that took place in your agency, specifically prohibited by Title 18 of the U.S. Criminal Code. And I don't think we've gotten a satisfactory answer. Have you or your legal department made efforts before the grassroots campaign was undertaken to ensure the EPA staff is familiar with the kind of activity that's prohibited under the Anti-Lobbying Act?
We actually were following OMB guidelines
Prior
relative to the
to?
use of thunder. Yes.
Okay. So that's even worse. If they've received training in the Anti-Lobbying Act and then engaged in lobbying?
We believe we actually followed those guidelines, yes.
Well, I think the GAO disagrees with that, and whether or not there's there can be an intent proven, the subterfuge and the optics of what took place there are certainly worth considering. I think that there's some valuable lessons here in the GAO's findings, not the least of which is that the administration and your agency is willing to go so far as breaking U.S. criminal code to push an agenda. We already knew that you were willing to go to great lengths to push that agenda, but this brings it into a completely different perspective. Secondly, the GAO findings tell us that these actions set a dangerous precedent for future rulemaking. So you've basically compromised the integrity of the rulemaking process.
Sir, they never indicated that we referenced any law.
I'm on my time right now, Administrator.
I'm sorry.
In the age of social media and electronic communication, it's deeply troubling that agencies are willing to use these tools to subvert the concerns of the affected public and drown out opposition to your own views. And it's obvious that you were trumpeting your own views and not taking into consideration the public's views when this is a public rulemaking comment period. So I don't know how, after all those revelations were made, did you expect us to believe that during the WOTUS rulemaking, the EPA actually took into account all the views by affected stakeholders, or were you just concerned about the views of your political allies? It appears to me that that was the case.
Sir, the GAO never indicated that we referenced a particular rulemaking. They never indicated that we said anything incorrect. They had one concern relative to anti-lobbying, which was a hyperlink to a program that we were touting as being really good. One blog from one individual in the agency out of thousands was done, and it referenced a hyperlink, and they could not go back and prove or disprove whether or not that NGO at some other place in their web page may have had an ability for people to contact Congress on other related issues or this one. So we are certainly sensitive to the fact that that hyperlink referenced an outside of EPA website. There are other agencies that flag that. We're considering and working with OMB on what we can do. But if you look at this, there was no intent and there was no lobbying on behalf on the part of the agency or a reference.
Okay, I think that we
effort.
can take this as an example and a validation of the fact that the rulemaking process is deeply flawed and needs to be addressed, because this kind of stuff to me is not reflective of the opportunity that should be granted to the affected stakeholders. Let me switch gears with you just quickly in the time I have remaining. I was just told yesterday that the EPA took action against a farmer who didn't comply with the SPCC rules on on-farm fuel storage by failing to have an SPCC plan for his oil storage tank that was 5,000 gallons in size. But the 2014 WRDA specifically says that EPA can only require compliance for oil storage tanks in excess of 6,000 gallons. Until such time as EPA completes its study and a new rulemaking process is undertaken. My understanding is that the study is complete, which recommends a lower exemption threshold, but the rulemaking is still not finished. So my question to you is, why is the EPA taking enforcement action against individuals who are not out of compliance? And isn't that a violation of the law?
Sure, I'm happy to look into it and get back to you. If it just happened yesterday, I'm really not familiar with it.
Well, is that kind of thing a regular practice by the agency?
I think we've actually been doing a very good job on the SPCC rules. Many of them, because of changes in threshold, like 96% of them are no longer impacted by this rule. And of those 4%, 97% self-certify. So we're doing pretty good.
Right. Do EPA agents take compliance actions like this because they know that farmers aren't willing to fight enforcement actions because it costs them more in legal costs than it would be to just go ahead and succumb to the EPA pressure? Am I off base in suggesting that?
I don't know why you are suggesting it, sir, but if that's your point of view, you can have it.
It is my point
but I don't
of view,
know
and it's the
anything
point of view
about
of
this
most
enforcement
people in my
action.
district who farm and are subject to EPA regulation. I yield back.
Jim yields back. Mr. Scott, 5 minutes.
Thank you, Mr. Chairman. First of all, Mr. McCarty, I think that you and the EPA have drastically manhandled and violated the rights of our farmers, especially dealing with this water issue. You did break the law. You did break the law. Now, let me tell you, Ms. McCarthy, in Section 15 of the Financial Services and General Government Appropriations Act, it expressly prohibits you from lobbying in support or in opposition to pending legislation or rule. Further, not only there did you break the law, but in Section 401 of the Department of the Interior's Environment and Related Agencies Appropriations Act, that's applicable right now, prohibited the use of the EPA's appropriations for lobbying. You broke the law. It needs to be admitted. It needs to be recognized. And furthermore, you spent taxpayers' money in the lobbying. And the GAO reports it's $64,610 that you spent in lobbying from February 2014 to 2015. Now, let's come clean with this so we can correct this. There's no way you're going to correct this if you don't realize that you've drastically overstepped here. And let's get that cleaned up. Now, why, you know, the other part that really gets in my craw is this. I was born on a farm, grew up on a farm. And there is a reason why farmers go and develop ditches and ponds and wells, and they're man-made, because that's an insurance policy for the drought. Our animals still have to be fed. They have to drink. There are many times when it won't rain for 4, 5, 6 weeks. And that's why we have that. The other point is, this is the farmer's private property, and it's not navigable waters. It's there for the purpose of being able to give us protection when that rain won't come. My little farm was a tobacco farm. And when you put the tobacco, you go to the tobacco bed, you got to put the plant in, and you got to have the water right there to go in with the plant. Suppose it doesn't rain. Now, that's on that farmer's property. He shouldn't be permitted for his own property. And then he shouldn't be fined, so you got to pay, the farmer got to pay for a permit on his own property for a puddle of water, or a ditch, or a pond, or a well that they made themselves so that they could be able to have that insurance in a rainy day. And then to violate all of that, the law itself, to go and lobby and spend taxpayers' money on it. That is a damnable thing to do to our farmers who are faced with so many other challenges. The EPA needs to reject this rule, recognize and admit that it broke the law, and then move to correct and say this will never happen again. Now, finally, in my last second, I don't want to go over time, but I want to raise this issue for our cotton folks on this, the chlorpyrifos. I guess a better way of saying that is Lorsban. Anyway, we need this for our cotton producers and for our pecan producers. As been said before with the chairman and others, our cotton people are going through a very serious time economically, and they don't need a doubt of whether or not they can use this pesticide. So will you please make sure we use that and hopefully put this business aside for the water rule, and let's move forward and let these farmers have some peace of mind.
Thank you for your passion, sir.
Chairman yields back. Mr. Desjardins, 5 minutes.
Thank you, Mr. Chairman. Ms. McCarthy, thank you for being here today. Just one follow-up on Mr. Scott's question. He pointed out that GAO determined that you violated federal law. Who was in charge of the covert propaganda and the grassroots lobbying? Who was the person in charge of that?
It is actually just part of our outreach and education, sir. There was no covert propaganda and there was no lobbying.
So there's nobody over that particular outreach? There was nobody in charge of that you're aware of?
Sure, we have communications folks that are doing it.
Who was the head of that? Who was responsible for that?
I'd have to go back and look at the exact time, but we have actually a large education and outreach group, but none of that.
Nobody was punished for it, though, right?
Of course, we don't believe
My
that we
understanding
did
is the person that's
anything wrong.
over it is now promoted and working for the White House, but that's beside the point. In your opening statement, in response to the chairman, you made it sound like Congress is imploring you to move forward with this WOTUS. Where did the idea for WOTUS come from, and basically who was in charge of drafting this package?
Actually, the WOTUS, or the Clean Water Rule, came because the Supreme Court told us that we needed to make improvements to the law based on science. We needed to prove a connection. We needed to do a better job.
So it wasn't Congress, like you said in your opening statement. It wasn't us.
It actually was followed up by Congress asked us to take action to address concerns, individual stakeholders, members of the ag community. Absolutely, people were looking for us to do a better job than the 2008 guidance and to respond to the concerns and criticisms that the Supreme Court.
But you went around Congress and you used a rulemaking process, correct?
No, sir. No, sir. We were actually asked to do a rulemaking for clarification. Whether you disagree with that rule or not is fine.
What's the cost of this?
But EPA didn't generate this on its own.
What is the cost going to be to implement this rule?
It's actually a net benefit of something in the order of $184 million.
A benefit, not a cost. Because I've heard that costs anywhere from $180 million up to $500 million, which that would change the way the rulemaking process works, correct? If the cost is over $100 million, you can't go around Congress the way you did.
No, actually, the $100 million threshold means we go through the interagency process, which we did.
Mm-hmm. Do you know Howard Shalansky?
Yes, I do.
Okay. Have you worked with him on this?
Yes, I did.
Do you know why he won't give the required documents to the OGR committee that we've been asking for since March 3rd of 2015?
I'm not aware of what you're referring to, sir. But
okay, we had a hearing about the rulemaking process and the fact that this was a major rule. And we've been asking, and actually have had to now subpoena these documents for over a year. You don't have any idea of why that they're ignoring our request?
I don't know.
You've not had any conversations with him?
No, sir.
Okay, is this directive more from the White House?
What directive are you referring
to?
The
WOTUS ruling itself.
No,
the waters of the U.S. Because it's certainly not from Congress. We voted both in the Senate and the House to stop
I just explained to you where the impetus came from.
Mm-hmm. And the courts have blocked this, correct? The implementation.
It is being litigated in one district court, and it's now with the Sixth Circuit, where they're looking at whether or not the district court has jurisdiction, or they do. But you're absolutely right. We are now stayed in terms of its implementation until those court issues are resolved.
Okay, well, you act like you're doing us a favor, but yet we have 31 states and many agriculture organizations filing lawsuits against you. So you don't think that maybe there ought to be a reason for pause? Maybe we ought to scrap this thing, go back to the drawing board and do it right?
We'll certainly hear from the courts as to whether we met the legal test in terms of its merits.
So why did the EPA decide that it was necessary to do this?
Because of the lack of clarity in the inconsistency in the unfairness of the current process.
Okay, but under the Clean Water Act, you were restricted to navigable waters. Mr. Scott talked about farm ponds, stock ponds where cattle drink out of. Is that a navigable water?
The actual navigable water, the Supreme Court has told us that goes well beyond what we would traditionally think of as navigable, and we have to then protect waters that have the ability to significantly impact the biological, physical, and chemical integrity of navigable waters.
You understand?
Does it respond to ditches on farmlands? We've done a really, I think, good job, if you look at the Clean Water Rule, to make sure that we're clarifying the word ditch that's in the clean water rule, not in.
It would take
in
another
our
10 minutes
rulemaking.
for you to describe what's a ditch and what's not a ditch, but I'll just end with the fact that, America's frustrated right now with big government. That's the #1 issue with Americans,
sir.
is the overreach of federal agencies. So I would hope that you would withdraw a little bit, take your time, and get this right. Thanks for being here.
Gentleman's time has expired. Ms. Lujan Grisham, 5 minutes.
Thank you, Mr. Chairman. Director, as you're aware, on August 5th, 2015, the EPA team that was investigating the contamination at the Gold King mine in Colorado accidentally released 3 million gallons of wastewater into the Animas River, which then flowed into the San Juan River, which is in New Mexico, part of it, and Lake Powell, which, I think that you actually estimated that in that accidental release, there were 880,000 pounds of metal that was deposited into the Animas River as a result of the release. Now, while the initial plume dissipated within several days, I want to alert you, I think you may already be aware, that there remain very serious concerns about the long-term impacts, in both environmentally and for public health. And I am aware that both the state of New Mexico, through primarily their Environment Department, but certainly in my communications with the governor, and the Navajo Nation and its president, that they have real concerns over a proposed one-year EPA monitoring plan, which doesn't do anything about monitoring groundwater, plants, crops, wildlife, and certainly doesn't take into consideration continued runoff. I hope we don't have it too soon, but a spring runoff, which means that all that sediment gets moved again. And so I would agree that the state is correct in assessing that there needs to be a long-term monitoring impact, that there ought to be a plan that involves their independent review. They're there, they're familiar, they're aware, which I realize is difficult. 2020 hindsight, we all wish we had that you want that expertise so you don't have these kinds of issues, you don't have these kinds of accidents, and that you don't have information that may not be accurate or really relevant to the area in which you're testing. Can you talk to me about your conversations with the state of New Mexico and the Navajo Nation, and whether you're entertaining to support them and fund them and give them the resources to assure that the public health of the citizens of that state are protected?
Well, we're certainly going to do just that. In a couple of different ways. We know a lot of those states and the tribes that were impacted by this spill have been discussing with us reimbursement of their expenses. Particularly, your state did a great job at responding to that. We are sitting down with them looking at both a short-term monitoring program and a long-term one that doesn't just look at the area of the spill, but does a much broader look at the watershed in general, and how we can not just do that with EPA scientists, but they can be engaged because they have scientific expertise. In the universities in your area have great scientific expertise. EPA has identified funding for that, and we're going to work with them to make sure that we do the monitoring that's necessary to understand any impacts.
Because I think that robust partnership will bring about credibility. I can't agree with you more about that expertise, which leads me to the second question I want to ask, which is related to the MS4 watershed permits in the Middle Rio Grande. It's a completely separate issue, but it includes 15 individual entities and jurisdictions. The Middle Rio Grande region is one of 3 in the country that were chosen to pilot a regional watershed approach, and it's the only region in the western United States to participate. And the problem is, as you're looking at all of these water issues for clean water related activities, you're including requirements that are developed for eastern climates. And I don't think that we're using the right expertise, and I will tell you that everyone in these affected jurisdictions is really struggling in their relationship with you, because the aspects of the permit do not make sense in arid environments. requirements, and they quite frankly conflict with all of our state water law and many of our federal water law compacts. Stormwater regulations need to have the flexibility to make sure that local managers can suggest alternatives that make sense for an arid region. Are you aware that we are having these conflicts, and do you see a way for us to have much more flexibility so we meet your overall goals and are participating productively, but we can do it correctly?
Well, all of our water programs, by law and by intent, is a partnership between EPA and the states. I did not know that there were concerns that have been raised that have not yet been resolved in these discussions, and they have to be resolved. They have to be resolved in a way that makes sense for those communities, and you are absolutely right. Flexibility is the key to doing that.
I'm out of time, Mr. Chairman. Thank you for your patience again, and we'll work with you to get this resolved. Thank you, sir.
Thank you.
Gentlelady's time has expired. Mr. Gibson, 5 minutes.
Thanks, Mr. Chairman. Ma'am, I represent parts of upstate New York,
Yes.
11 counties, 162 towns. Among those, the town of Hoosick. And in Hoosick, we have a village, Hoosick Falls. It's a very proud area, and for good reason. Hardworking, good folks. And these are really challenging times for Hoosick Falls right now. Due to a chemical that's been detected, PFOA, we have not had potable water in Hoosick Falls now for over 6 weeks. We're working on that. We have carbon filtration process ongoing. We do think in several weeks we will have potable water. And at the same time, we're now monitoring blood levels of the citizens, and we're beginning the long process of a comprehensive health study. And we're soon to begin the process of identifying the source of contamination and ultimately identifying an aquifer that we can be confident of going forward. Ma'am, in March of 2015, we contacted the EPA, and the response then was that PFOA was an unregulated chemical and that it did not pose a health risk. At the end of the year, specifically on the 17th of December, EPA came out with a statement and said that the water is not potable, and furthermore that it posed a risk to health. And so my question is, how do you go about making this determination, and what changed from March to December? And before you answer that, you know, in my research as I've worked on this, I have come to find out that there are many unregulated chemicals. And ma'am, I think we need a method. We're going to have a method that we then, you know, go through all these unregulated chemicals and have a way, hopefully with analytics and automation, where we can compress and go through all the health data so that we can come to these determinations. Because I can tell you, my people, they're hurting and they're very disappointed, and we're looking for answers.
Well, you know, I share your concerns and your interest in finding ways in which we can more effectively and quickly address these new chemicals that are entering into some of our water systems, and we're finding across the country. Now, I believe that our region has been pretty aggressive in working with the community, and I want to thank you in the community for how quickly people have been reacting to this situation, getting bottled water out, getting a new carbon system in. EPA has been trying very hard to keep up with new chemicals that we're finding, to do the science behind that. There is a systematic process to do that. That's written into the law and the rules about recommending first, identifying, going through a listing process that's public before you can regulate, and actually working with the states and local communities to adopt those regulations.
So ma'am, just so I understand, I'm hearing you. So is that the answer to my question?
No, it's not. That's the preface of how difficult it is now and why I agree with you that we need to do better. We are looking at more automation and how we do the science around this. But frankly, if Congress would continue their push that they're on re-upping the Toxic Substances Control Act, we'd have more ability to understand what chemicals are going into products in the system and what challenges they may pose, so that we can be better able in the end to find out where they are and what they're doing and the science behind those.
So from March to December, was it was there something that changed in our understanding of PFOA, or was it just a latency in understanding that there was a danger out there? This is what I'm not clear on.
Yeah, I'll have to go back and talk to the region because I'm not sure that I can specifically answer your question. I believe that the testing that was provided to the region early on was in a system that wasn't currently in use. But when we found out that there were existing drinking supply wells that were being used, part of the challenge for us was that our recommended levels, in some cases, was fairly high, is currently being reconsidered. We were trying to give the best information that we had based on the science we knew, and that's why there was a continued debate back and forth on the level and what was safe and what wasn't. But that's because the science was changing and the tests were changing, and what we knew to be the case in terms of what people were drinking was changing as well.
Okay, ma'am, we'll stay in touch on this. Chairman, I'm going to have to submit for the record a second question that has to do with the Hudson River, and with that, I yield back.
Chairman yields back. Ms. Custer, 5 minutes.
Thank you, Mr. Chairman, and thank you to the Administrator for being with us today. Always great to have a New Englander in our committee. I'll be quick. I had 2 questions. The first one relates to this Waters of the United States ruling, but in conjunction with the EPA regulation on pesticides and the Fish and Wildlife ruling regarding the long-eared bat. And my question on behalf of farmers, landowners, and timber owners in New Hampshire is how will your agency coordinate with USDA and Fish and Wildlife to minimize confusion about the interplay between these 3 rules, if you follow?
That is a very good question that I'm not sure I can answer. So I will have to get back to you because you've just baffled me with the bat question, connecting with the clean water and the other issues I understood.
Yeah, I mean,
that
basically what I'm
monkey.
trying to give some guidance because I have more trees than people, so it's a big timber area. I've got farmers, I've got landowners working on conservation, and as these 3 rules come together, it's obviously going to limit the way they can use their property, and I just want to try to give them some guidance because you know, I just wonder if there's coordination is basically what I'm looking at. And
Well,
if
certainly I haven't been a part of it, so I better figure it out.
That would be great. Thank you. Thank you very much.
Okay.
Yeah, the bat threw me the first time too, but apparently it's an important bat. So,
Well, they all are. They all are. Actually.
And then the second question, this relates to the Clean Power Plan and the biomass energy. I'm the co-chair with my Republican colleague, Mr. Westerman, of the Biomass Caucus here in the Congress. I understand that the Supreme Court issued a stay this week on the Clean Power Plan. My question goes beyond the stay. There's confusion in the biomass energy world, stakeholders, regarding whether or not biomass will be treated as a carbon-neutral form of energy. We've submitted letters to you. I'm just curious whether a determination has been made and whether biomass will be treated as carbon neutral under the Clean Power Plan.
Well, that's a question I understand, so thank you. You helped me recover a little bit. The biomass is actually a really important part of, and we expect it to be, of many states' compliance strategies that they would use for the Clean Power Plan. And so we know that there's been questions raised. The rule itself identifies biomass that we think is carbon neutral. That would be enormously helpful to consider. But we also recognize that there are other things that the states are looking for guidance. So we have actually notified folks that we're going to be pulling together a work group and we're doing already, I think, webinars on this to get people up to speed so that we can have the right questions and develop the right answers for how a state can feel confident to have biomass be an effective part of their compliance strategy. We're sure it will be. But there's uncertainties about what EPA might approve, and we want to make sure that we're working with everybody to get that done.
So I'd love to just issue an invitation from the Biomass Caucus. We'd love to set up an event here on the Hill with your team to educate members of Congress, as I say, bipartisan from all over the country, to learn more about this interpretation, and then we can help to take that back to
That
our
would be great. I
offices.
know that many of your members have prompted this, this workshop to happen. Maybe we could do it right after, and we can give you a sense of where we are.
Okay, that'd be great. I have to go to another committee, but I'll have my staff stick around to connect with you. Thank you so much. Thanks for being here, and I yield back.
Gentlelady yields
With
back.
time to spare.
I've noticed that. Thank you very much. Mr. Lamalfa, 5 minutes.
Thank you, Mr. Chairman. Ms. McCarthy, I appreciate your attendance here today and willing to answer all these questions. I'd just tag off of something that Austin Scott talked about a while ago, where there's a great concern amongst the racing community and the car enthusiasts that you have a regulation coming down on basically stock cars that have been converted for racing, and that if you want your outfit to be known as the Entertainment Prevention Agency amongst millions of racers around the country, I'd certainly, I'd recommend not pursuing that. So please check into that, and
I will, sir.
hear your
Thank
answer on
you.
that. Now, follow up on something from a couple months ago with one of your colleagues too. We have in my district something known as the Iron Mountain Mine above Redding, California. It's above the Sacramento River, which affects water supplies for 20 million Californians and many, many hundreds of thousands of acres of agriculture. Iron Mountain Mine situation wouldn't be that much different than the Gold King Mine and the Animas River situation as well. So I'd asked for a report a couple months ago from that. So would you please see to it that I can get that report so that I know that our situation there is stable on that, because we certainly can't have that affecting that many Californians on that mine. So thank you. On the issue of Section 404 and the exemptions that are provided for agriculture under the Clean Water Act, normal farming activities, ranching, forestry, et cetera, including very key plowing, seeding, cultivating, minor drainage, harvesting for that production of the food and the fiber and forest products, conservation practices, et cetera. No additional requirements, for example, that an activity be continuous are included. So now some of my constituents are saying that you had to have continuous cropping on these lands, otherwise you lose your ability to have that exemption. Nowhere in the law does it specify that, but that's what's being carried out in my district by EPA or your associates. Sometimes we refer to them as henchmen, but in our Army Corps of Engineers that are carrying out some very outside of the law activities with this regulation. So do you agree that Section 404 does make no additional requirements that an activity be a continuous crop as we see it in the law?
I'm not aware of it, but I certainly will have to get back to you on it, sir.
Okay, so continuous cropping activities we feel are not required under the 404.
And I don't know what actions you're referring to, so I should dig into it.
Well, they're coming down hard on people finding them or making them in some cases seek permits to do what they've been doing, or if they just let the land idle for a few years, which is good, following the land. And
that's what people do, sure.
Sure, and or for market conditions, whatever those might be, you shouldn't have to have a new permit, which sometimes folks seeking permits are afraid they're going to end up with a 3-year waiting process for getting the permit issued to them, which is the EPA or others going to Army Corps are going to pay their land payments and tax payments while they sit and wait for these decisions. So that another one, I have to go fast, I apologize. Section 110 of the Consolidation Appropriations Act of 2016 specifically prohibits funds from this act from being used to require a permit for the regulation, as was alluded to my colleagues a while ago. Are you aware of that exemption under 404 as well, under that appropriation? It was an appropriation amendment that specified no funds are to be used. So
For which specific?
It was under Section 110 of the Appropriations Act of 2016 that no funds are to be used under Section 404 requiring these permits.
No, I'm not aware of it. I will look at it.
Okay, well, that's a direct law that we
Okay.
put in place, so I'll look forward to your answers on that.
Thank you.
Again, moving quickly here, EPA and Army Corps of Engineers continue to rely upon EPA's interpretation of the Clean Water Act, imposing these regulations that stray far from the congressional intent. Again, indeed, you've mentioned several times following the law. It's pretty clear in the law on the exemptions, and then follow it by these amendments and appropriation activities that we've done here. So we believe that we're the ones that set that course there, and that the EPA is to follow it. So as long as they have exceptions to the exemptions, and that's where it's very problematic. There's exemptions on that, but if the EPA is looking for exceptions to exemptions in your rulemaking, then who's making the law here? That's what a lot of people are really concerned about, is that we're not the lawmakers anymore. Will you direct your agency to cease regulating activities that the Clean Water Act exempts?
We should not be doing anything other than exempting those activities.
Okay, thank you. My time's expired. I'll have some follow-up. I appreciate, again, your answers today.
Gentleman's time's expired. Ms. Walorski, 5 minutes.
Thank you, Mr. Chairman. And Administrator, thanks so much. I'm over here. I said hello earlier, and I again wanted to invite you to Northern Indiana, to my district, because a couple of reasons. So I've sat here, and you have too, for 2 hours. And here's the issue in my district. In Northern Indiana, where I represent, we have one of the largest manufacturing districts in the country, not just the Midwest. In the southern part of the state, we have coal mines, and we're strewn throughout with heavy agriculture as well. And so, you know, I look at this, and I've said since the day I came to Congress and even prior, Indiana's a good role model for being good stewards of the environment and being good stewards of the economy. And I could show you in my district places where, you know, we're really out of the box, and we're, you know, doing things that are incredibly creative to be so much more good stewards of the environment. But nobody is a better steward of the environment than the family farmer, because their complete livelihood depends on taking care of that area. So I do agricultural tours every single time I'm in the district, and on the last agricultural tour, you know, we've been able to diversify, we've been able to do great things in our state, we've been able to do some really, you know, clean water things I think are exemplary. But I came away from there, and I'm old enough to remember when the EPA was really considered a partner with industry, a partner with farmers, and really kind of came alongside, especially in our state. We have an incredible Indiana Department of Environmental Management that comes alongside, not to be punitive, not to penalize, but to incentivize and to keep people from really getting in trouble. I came away from this agricultural tour really having an understanding that, in my mind, what I heard from my farmers is that today's EPA has become a punitive revenue generator for big government. And it bothers me, because I sit on this committee, and I know there's a lot of well intentions, but when it comes to this WOTUS rule, and I understand exactly why the frustration is so high in this room on both sides. This is not a partisan issue today. This is an issue of Americans and farmers and members that represent them trying to come to grips with an understanding of, really, in a state like Indiana, we are in a target virtually in every single portion of what we do and what we lead our nation in coal, in ag, and in heavy manufacturing. The toll on jobs because of this issue of heavy-handed government, there's really no other way to explain it. I understand your intention, but I also understand that I've been around long enough that we've been able to have great gains in this country with a partner in the EPA. And when we talked about humility and we talked about attitude, there is a gigantic tone problem. When I come out of my district hearing from people from all over the state saying, you know, it's a punitive regulating system, and when EPA comes calling, we don't even have a chance to even implement rule number 1, and here comes implementation of rule number 2. And I'm curious, especially on WOTUS, because I agree with my colleagues here. I would ask you to pull this rule and bring shareholders around this, and let's do it right, let's do it balanced. I'm not calling for one extreme or the other. I believe there's a balance between good stewards of the economy, and I can tell you that my state does that. But my question is this. So when we talk about, on one hand, you say the EPA doesn't intend to regulate every ditch. On the other hand, we look at actual implementation of the rule. The ditch exemption appears to leave some room. So here's my question. So is the ditch exemption automatically given if a business, farmer, or local government believes it's exempt, or do they have to prove it's exempt?
The way in which the law works is that if there is a question that you're going to be destroying or polluting what might be a water.
A question from the EPA?
No, that would be the individual landowner might be concerned that their activity would be doing that, and they may
On their
need a
private
permit.
land?
On their private land or elsewhere, then that question is raised by that landowner, and they ask the appropriate questions. That usually and often goes to USDA or others and filters its way through. But it is not, we are not changing the dynamic of how the rule has been, how the guidance was implemented.
Yeah, but let's just say worst case scenario. Worst case scenario, some farmer ends up, somebody somehow says he's not in compliance and he must do X, Y, Z. With the waters of the U.S. rule as it is now, and what we're talking about with this exemption, could a farmer potentially face any kind of legal action if he was strongly on the side that he is not out of compliance and somebody from an EPA comes in and says you are? If this goes all the way to the end, could somebody like a farmer be penalized and face legal action and have to defend himself on a question of water on his own land?
There have been enforcement cases. There have not been a great deal compared to the way in which people get to work together to answer these questions and to get permits done. I will honestly tell you, in my heart of hearts, we worked very hard on this rule to make the clarity you need so that you as a farmer can actually be assured that if someone asks that question, you know the answer.
Yeah,
I know,
in all honesty, I think you missed the mark, and I would again ask that this rule be repealed and we go back and allow it to come to the table. Thank you, Mr. Chairman.
Appreciate
Sorry
it.
for the extra time.
Time's expired. Mr. Abraham, 5 minutes.
Thank you, Mr. Chairman. Thank you, Administrator McCarthy, for being here. I'll echo certainly the bipartisan support you've seen here, that our farmers, ranchers, foresters, aquaculture farmers, they are their own best stewards of their property. They're not going to do anything to harm their livelihood, but more importantly, nothing to harm their children and their family. To Mr. Austin Scott's reference of asking you the price of cotton, I won't put you on the spot and ask you the growing planting season of cotton or corn or soybeans or anything like that, but it lends to the question as I'm fearful that the EPA as a bureaucracy wants to literally drive the car but doesn't know how to start the car. And when you don't know the basic facts of growing times, when you apply pesticide, and how important those windows are to maintain agriculture integrity, then it begs the question of who should know these answers. And my answer to myself is you should know. We talked about pesticides, so I'm going to go to my questions here. And it with respect to your agency's roles in reviewing and approving the use of pesticide, does EPA examine the health and safety of a herbicide under the Federal Insecticide, Fungicide, Rodenticide Act any differently if its proposed use is tied to a genetically engineered plant versus if it's not? And does the agency meet its registration obligation equally in both cases? So I guess my question is it common for products tied to GE plants to be at your agency several years while registration dates are renegotiated multiple times?
My understanding is that we have had a great deal of success in eliminating extensions of time for overall for all of our program, actually quite remarkably. We're mostly keeping to those windows. Are there additional challenges with genetically engineered products? If they are, then that's where the science comes in and we explore it. They are not treated differently than looking at how we always look at pesticides, which is by the science, trying to stick with the legal timelines and windows that we have to make our decisions.
And I'll follow up with a question on the science issue. The President has stressed the importance and the value of transparency in EPA's actions to ensure the use of sound science and reliable data. EPA is increasingly reliant on epidemiological and modeling data, looking at the occurrences, correlations, and extremely unlikely scenarios to essentially overrule volumes of actual hard science laboratory and monitoring data historically relied on around the world for decades. Why was this fundamental change in policy not put out for public notice and comment so that impacted stakeholders would have an opportunity to comment on this transition to such a heavy reliance on just the worst-case scenario presumptions, modeling, and epidemiological studies?
I'm not aware that there's been any change in policy direction, sir, so I'm happy to look at the specific decision that you're referring to.
And I will look forward to that answer, because I am under the understanding that there has been quite a transition away from the hard science and looking at some.
So I'm happy to answer it if that's a concern.
And my last question, you know, and let's keep dealing with these this raw data, this hard science. I've heard about serious matters regarding EPA policies based on human research data that may not be reliable. For years, EPA has relied on hundreds of quality studies evaluating all aspects of human susceptibility to pesticides. These included studies designed to make sure that children would be protected, and certainly we want that. Even though EPA uses those high-quality assessments for 20 years, EPA now relies primarily on epidemiology studies and some journal articles in which EPA has never, I am told, again, seen the raw data to determine if these studies are reliable or accurate. Case in point, I'm told that Columbia University, who conducted a key study, refused to provide the raw data to EPA, even though EPA partially funded the study. So EPA is likely relying on information based on raw data that cannot be reviewed for accuracy. And I'm running out of time, and I'll submit this question. Is it correct that the EPA has not gotten access to that raw data, or are you simply refusing to disclose them? And if you have the information, why are you not disclosing that information for the public to review? And I will look forward to your answers to that question. I yield back, Mr. Chairman.
Gentleman yields back. Mr. Newhouse, 5 minutes.
Thank you, Mr. Chairman. Administrator McCarthy, thank you for being here. Let me start by calling your attention to a letter I sent to you last month in regard to a company called OMAC Wood Products. It's in OMAC, Washington, and Okanagan County. As you know, we've had the last 2 years record-setting catastrophic wildfires.
Yes.
It's had a tremendously negative impact on our communities. Yeah. This OMAC Wood Products company is one of the largest employers in this small community. I think over 185 people work at the mill, $60 million impact to the community. Unfortunately, they've announced recently that they plan to shut down at the end of February. People in the city of OMAC are working very, very hard to find someone to come in and take over the mill. One of the issues, though, is they don't have an operating permit. 2 years ago, EPA promised a rewrite of the permit that would more accurately reflect the operations of the plant. And I can tell you, without that permit, they're having a very difficult time finding anybody interested in reopening the plant. So if you could look into that, I would very much appreciate your
I would be happy to do that.
I have a copy of that letter. It is submitted for the record, but I can give you another copy if you would like.
That would be great. Thank you.
So a couple of questions, Administrator. Section 303 of the Clean Water Act clearly gives the states the authority to develop water quality standards and then submit those plans to you to confirm that they comply with the CWA.
That's correct.
I don't think Section 303 gives EPA power, though, to establish those criteria for the state. And last year, EPA indicated it would reject the state of Washington's water quality standards on the basis of two things. Number one, that it doesn't account for the consumption of 175 grams of fish per day, which I might add is the equivalent of eating 38 cans of tuna a month. And number two, for people who actually consume that much fish, it doesn't account for the cancer risk level of 10 to the minus 6. Or 1 in 1 million. So I'm concerned that your agency's proposed rule is significantly more stringent than required to protect human health. It is inconsistent with existing policy and could cost my state billions of dollars for compliance. Could you discuss for me just real briefly, and I know we have a short amount of time, on how EPA arrived at these levels and explain why your agency is seeking to impose standards that far exceed your own water quality guidelines for states?
Well, I think that I am very familiar with this issue in terms of work that's going on between the state of Washington and EPA, where the state of Washington has recently proposed water quality standards. We have been starting a process to do that ourselves. We're perfectly happy to defer to the state on their water quality standards, should those come out in a way that we think does two things, is safe for human health, as well as protect the tribal treaty rights, which we're obligated to protect under treaty law.
Okay. Well, let me follow up then real quickly. As for your proposed cancer risk level, in order to have a 10 to the minus 6,
yes,
you would need to reduce some of the agents on the EPA's toxic pollutant list to, now get this, less than the naturally occurring levels. It means that the river, as it flows naturally, would not meet the levels. A 2013 study conducted by Washington State industries, counties, and municipalities found that even the most advanced technology available, and with billions of dollars in upgraded resources, few facilities would be able to meet those standards. So my question is, where does EPA think it derives the authority or the power to tell states they have to meet these standards and that they have no part in formulating, and number two, are in no way grounded in sound science?
Well, we can certainly have this conversation because I know we're running out of time. But I will assure you that the region working on this, our Region 10, is in close contact with Washington and stakeholders in the business community there to understand how we can come to a conclusion, either through the state effort or our own, to be reasonable, rational, make sure we have standards that can be achieved, and that in no way take away the flexibility that states have in terms of how they achieve it.
I appreciate that answer. And I do have more questions, but I'll have to submit them for the record. Again, thank you for being here.
Thank you.
Gentleman
Thank
goes
you,
back.
Mr. Chairman.
Mr. Kelly for 5 minutes.
Thank you, Mr. Chairman, and thank you, Administrator, for being here. My first question is, 3 years ago, Mississippi farmers and beekeepers created a Mississippi Bee Stewardship Program to enhance cooperation and communication between beekeepers and pesticide applicators. This has increased not just goodwill between these two groups, but we expect to find that this has increased pollinator health as well. Unfortunately, despite the good work that Mississippi is doing, the EPA is undermining those relationships. While both our farmers and beekeepers thought they had addressed many of their pollinator and pesticide issues, farmers in my state are losing access to key products and will be unable to protect their crops from pests threatening their livelihood. Additionally, beekeepers have concerns that an economic hit to the farmers would mean that they would be unable to host bees on their farms. Please explain to me what EPA is doing to ensure that my constituents will have the time-proven products and the new effective products available to meet their needs.
Well, one of the things, we should really talk about where this concern is coming from, because I know in working through the pollinator strategy, we recognize that one of the key things that needed to be done is an agreement and an understanding between beekeepers and their own farmers about how to protect those pollinators while at the same time allowing those crops to be properly managed. So if there is a disconnect there, I would really love to understand that, because it was one of the highlights that said the federal government doesn't need to get involved in this as long as that communication is working and happening. And so if we have missed the boat, I'd really love to be able to work with you on it to figure out how we might turn that around.
And I will. I'll make sure that we get you that information so you understand, because they actually started before you asked them to, and now they feel like they're...
Exactly. This is the conversation we wanted to have happened.
Okay. And now second, and I'm just going to, I don't know, I was going to joke about our accents because, you know, I didn't know if we needed an interpreter or not, because we kind of speak a little different English.
I can understand you.
But after the hearing today, you know, I'm not sure that we're not different in more ways than just our accent. And I think one of the smartest terms I heard today was regulatory humility. Yep. And I can tell you, I've not seen that displayed. And I think if you look back, I think you have 32 states who have filed a lawsuit over WOTUS. I think you have both the House and the Senate, who the majority of members, regardless of which party, think it's not being implemented correctly. I think you have courts that are saying that it's not being implemented correctly. And what I see is the EPA sticking a flag in and saying, we're right and the rest of America is wrong. We are right, and we will defend, and I've heard several times you say, we defend this action. I don't agree with what the court said on that. I don't agree with GAO that we broke the law. I don't agree with this. We will defend our science. We will do this. That is not humility. That is the opposite of that. That is arrogance. I'm smarter than you. Mm-hmm. I don't care how many of you are and how many different backgrounds you come from, but I'm smarter than you, and I'm right, and you're wrong. And I think a member asked you earlier, repeal WOTUS. Do away with it. It's not that it's a bad idea, but the rule that we have now, I can tell you that the majority of America does not believe protects them, and they believe it is punitive and not helpful. We need clean water. No one understands that more than me. One of the most crucial resources we have in America is clean drinking water, is water to water our crops. We all want the same thing, but the rule that we have now does not accomplish that. But we are so entrenched that we have to have this rule, and I think if you would repeal the rule, step back, get with Congress, get with farmers, get with environmentalists, get a whole group of people in a room and say, what do we want to achieve, and what is the most effective way to do that? And let's all take our pride out of it, because we're all prideful, regardless of what we are. But to get back to the humility and get the smart people in the room, get a group or a commission together, and let's come out with a WOTUS that works. Because I can tell you, businesses, farmers, legislatures, courts, everyone right now knows that this WOTUS rule that we have is not the right rule. Let's quit sticking a flag in the ground and defending something that doesn't work, and let's come up with something that does protect our clean drinking water. And Mr. Chairman, I'll yield back.
Gentleman yields back. Mr. Goodnight, 5 minutes.
Thank you, Mr. Chairman, and welcome, Administrator McCarthy. I want to go back further than WOTUS and talk about the EPA's Chesapeake Bay TMDL scheme, because that really is the precursor to what's going on nationwide with WOTUS. And I think that you would agree that the Bay TMDL is both significant and unique for a variety of reasons. In fact, early in the implementation process, EPA documents mentioned that many specifics of the Bay TMDL were novel in comparison to past EPA TMDLs, and that this blueprint could serve as a template for other watersheds throughout the nation. Further, the concerns voiced by agriculture, forestry, and home building industries, in addition to some local communities and to the TMDL's numerous legal challenges, speak to the enormous impact that the EPA's actions have had and will continue to have in the Bay region. Given this, shouldn't the EPA have conducted an analysis to estimate the cost of such an important rule?
It's my understanding that we have been in that process
since 2009, and you're almost to the halfway assessment point, and you've implemented this process but have never done a cost-benefit analysis to determine whether the cost of this to all of these parties isn't, and the taxpayers of my district and all the other districts in these 6 states isn't greater than the benefits to the Bay?
Well, sir, I think what we tried to do was to allow states the flexibility to choose their own paths forward, and because of that, it would have been extraordinarily difficult to provide any certainty about what that cost might be.
That's actually not what happened, if I may, because the states have, for the past quarter century, done just that. In fact, that's what the Clean Water Act provides for. It says that the federal government gets to set the standard, and the states get to write the plan and implement the plan to meet the standard. And a lot of progress was made over those 25 years. Yes. Sedimentation has been reduced in the Bay by more than 50%, nitrogen and phosphorus by more than 40% before this TMDL ever even began. And yet the EPA said that's not good enough and went ahead with putting pressure on the states, threatening the states that if they didn't change the way they did it, that there would be costs and other consequences to them. So, in fact, up until March of 2009, your agency had assured us that no TMDL would be implemented before there was an economic analysis. So how much has your TMDL cost the affected states, and on average, how much has the TMDL cost the average farmer or producer in the Chesapeake Bay watershed?
I can't answer that question yet.
I know you can't, because you never did the homework. You never did the work necessary to prove that this was a worthwhile undertaking. The state of Virginia estimated that the cost just to Virginia alone would be more than $16 billion. But the EPA never came back and said, well, here is a calculation of the added benefits beyond what was already taking place. The Chesapeake Bay is getting healthier, has been getting healthier for many, many years. That's a good thing. We all support that. But when you take the law into your own hands and do it contrary to what the Clean Water Act provides, you get lawsuits rather than progress. Your agency has been implementing the TMDL for several years now, and in fact, I understand that next year you'll be releasing the Chesapeake Bay TMDL midpoint assessment. Therefore, it would seem that you would have had ample time to conduct such an analysis of the cost and the benefits of it. Why did you not conduct an economic analysis prior to implementation, or at least at some point in the last few years?
Sir, we are in the midst of that process. I do not know when it will be completed. My understanding is that it is being worked on by the agency.
You may well be well past the midpoint assessment before you ever determine whether this should have been done in the first place, and therefore all of the costs that have gone forward, if they were not justified, then the EPA should not have issued regulations without having that done first. Does the EPA not view the financial impact of the rules it inflicts upon America's farmers and homeowners and taxpayers and small communities that dot the Shenandoah Valley in my district? Do you not view that financial impact to be of importance?
One of the reasons why we're doing the TMDL the way we are is to allow not just us to consider the most cost-effective path forward, but allow the communities themselves.
Well, Mr. Chairman, my time's expired, but I really have to express my ongoing dismay that this agency, for all these many years that we have been talking about this, have received just that talk and no information that would justify this major impact on these 6 states, which have, quite frankly, been the guinea pigs for the rest of the country, which is now facing a similar assault under WOTUS, and why both of those measures are now before our courts. Thank you, Mr. Chairman.
Gentleman's time has expired. Mr. Mulliner, 5 minutes.
Thank you, Mr. Chairman. Administrator McCarthy, thanks for being here with us today.
Thank you.
I'm represent from Michigan and am neighboring Genesee County and would like to talk with you about the Flint water situation. And as of yesterday, there were some concerns raised by a family in Flint, and you may have heard these concerns, but you know, their point was, Melissa Mays, as reported in the Detroit Free Press, said that we saw more information on Google than we did from the EPA. We asked them for help and got nothing. And I guess what I'd like to do is, you've been to Flint. You were there, I believe, on February 2nd, and really put the focus of blame on the state. And, you know, the governor has apologized. People have lost their jobs in the state over this matter. The EPA Region 5 Administrator, Susan Hedman, resigned. Was that over the Flint water situation?
Her explanation to me was that it was because she knew that she had already become a focus of attention, and she thought the entire focus should be on what we do for the people of Flint. It was a courageous act on her part.
Do you still maintain, as you did when you came to Flint, that the EPA did everything right?
I did not maintain that. What I said was that a situation like Flint should never have happened.
Right.
I explained what I thought were inadequacies of the state oversight and primacy. They are the ones that have the authority under the law, and they're the ones with the primary obligation. But I in no way said that EPA, I had done some kind of thorough analysis of what else we could have or should have done.
Well, let's just analyze it for a minute here, because my understanding is the EPA was aware as of February of last year that corrosion controls that would have prevented lead from leaching from the pipes was not being implemented, that there were serious concerns about, you know, raised levels of lead. In fact, above the enforcement action level of the EPA. EPA was aware of that and did nothing. We're almost a year later and EPA did nothing. Can you explain to me why that happened?
Well, I would say that I believe that in April of last year was when the state actually told us and corrected a misimpression they gave us that corrosion control was not happening. EPA vigorously from that point forward recommended to the state that they take action to get corrosion control up and running. Were there other things that we could have done or should have done? That is the focus of our attention at this point.
If I could
but we did oversee this
So
and
you're
recommend the appropriate steps for the state to take.
So you're saying that was in April?
I believe so.
My understanding is on February 25th, a resident from Flint, Ms. Walters, who had 4 children who have lead poisoning,
Right.
Contacted Miguel de Toro, a manager at your EPA Midwest Water Division, informing him that Flint is not treating water with standard corrosion controls and that prevent lead pipes from leaching lead. Also, Del Toro, your employee, learned that the taps were being pre-flushed for several minutes prior to sampling when they did water tests on this. So that is February 25th. The EPA has been notified that the corrosion controls are not being implemented and that the testing process is flawed. Now, my understanding is under the Safe Drinking Water Act, you have the authority when for action authorized when there's imminent and substantial endangerment to health. And so my question is, if you knew this in February, why was there no action taken for almost a year?
Well, my understanding in February was that we did ask the state of Michigan whether or not corrosion control was happening. They gave us an indication that it was. We relied on that, but at the same time, we did work specifically to test Ms. Walters' home, and it is not unusual, nor is it an indication of corrosion control happening or not, to have a high lead level in a particular home that can occur for a variety of reasons, including a disruption in the street. So one house does not dictate whether corrosion control is happening and effective, but in no way did Miguel ignore this individual's circumstance
and believe me, I'm
or
not saying,
contact the
I'm not
state.
saying Miguel did. I'm saying the upper levels of the EPA did. And that's where because Miguel actually emailed colleagues at the EPA, relaying his concerns about this faulty testing mechanism. And also, in follow-up tests, when they actually used the right testing mechanism, there were lead levels of nearly 400 parts per billion, 27 times the EPA's threshold. That's March 3rd, again, almost a year ago, and still nothing happened. Now, I want to go again to June 24th, again, when Mr. Del Toro wrote to the head of the EPA's Drinking Water Division, calling the Flint's lack of corrosion controls a major concern. Again, no action from the EPA. Finally, I'm told that rather than taking action, a legal opinion was requested on the authority of the EPA to step in. I mean, I got to believe that anyone who looks at the documentation of the law would be able to give the opinion that the EPA has authority in this matter. Wouldn't you agree with that?
Well, when you say no action was taken by EPA, I think you minimize the communication that EPA had that we normally have with states that are very clear that corrosion control should have been done from day one and it needed to continue. It was the state of Michigan that was challenging whether or not additional testing was necessary to make that determination.
And people have lost their jobs over that. Now, the question is, if you knew that it wasn't happening, why did you not take action?
I can explain to you my interaction with that, but it is a much longer conversation
Well-
than that. We clearly did everything we could to get the state of Michigan to do what they were supposed to do. When I became aware and engaged, that is when you saw an enforcement action taken.
And my understanding is the communications between the EPA Region 5 regarding this matter have been requested. The governor has released all of his communications. When can we expect to see the documentation on the communications from Region 5?
We have
EPA?
numerous FOIA requests that were in.
But this is pretty important.
There is nothing actually more important right now than getting that city clean water, and you'll see a large federal presence, including EPA, who is responsible to get that done.
Okay, well, when...
John, you're well over.
But
Thank you, Mr. Chairman.
I will respond, sir.
Well, I would like to know when you're going to have those documents public, I guess is the question.
Okay, I'll be happy to take that back. We have a number of requests. I don't know what the schedule is.
Gentleman's time has expired.
Thank you, Mr. Chairman.
Mr. Davis, 5 minutes.
Thank you, Mr. Chairman. Administrator McCarthy, thanks for being here. Did your staff prepare you for a question for me about individual septic systems being included in the definition of a sewage treatment facility in the
No.
Lotus Rule?
No.
They did
I
not?
slap them?
Yes, I believe last time at a T&I hearing, I said they should be fired if they didn't do it because this would be my fourth time. Do you believe individual septic systems are included in the language that says sewage treatment facilities should be exempt from the WOTUS rules, the WOTUS clarification?
I'm not familiar with the issue, sir, so I don't want to venture a yes, no answer.
I will remind you at a joint hearing between the House and the Senate on T&I, I did ask you the same question.
Really?
Your response was that we don't regulate individual septic system discharge for non-source point pollution, but you do. And I still have yet to have my question answered if they would be considered under the sewage treatment facility exemption under the existing WOTUS rule. So I don't have a lot of time left. I got some other issues I want to get to.
Go ahead.
That's okay. I'll get back to you, and I'll give you guys another chance the next hearing. But I am disappointed that your staff once again did not have a prepared answer on this, knowing that I was going to ask for the fourth time. That just makes me, as a member of Congress, feel as though this is more of a check-the-box issue for the EPA and those who work with you. And I'm sorry that they did not prepare you for that.
I
But
have great respect, and I would not want you to think.
I, as a former staffer, would not put you in a situation like that again. This is very disappointing to us, and I'm disappointed in those that are sitting behind you. I do want to ask you, I know you mentioned earlier in the hearing that you're trying to ensure that there's a better working relationship between the ag sector and the EPA. You know, there are a lot of folks that don't think that the EPA actually accounts for the economic consequences of some of your regulatory proposals. I also asked you at the last event, our last hearing we had, whether or not you have worked with the USDA to appoint a member of agriculture to the EPA Science Advisory Board. That was my language in the Farm Bill that I offered 2 years ago. What is the status of getting that person appointed?
On the standing committee?
Yes.
Yeah, we actually, as recently as last week, met with USDA so we can finalize that standing committee. We understand how important it is, and we have been working hard to make sure that we respect people's interest in getting the right applicant pool, and we'll be working with USDA on those choices.
I appreciate that. It's been 2 years since the passage of the Farm Bill. This is something that I asked you about before.
That I am aware of.
I just don't think the EPA's actions, and again, I don't expect you to take away from every hearing our concerns, but I do expect the folks who are sitting behind you to follow up. And my legislative intent was to get somebody from production agriculture, get somebody from agriculture to work with you so that maybe when you came here today, you wouldn't have had to talk about how you're going to work to bridge that relationship, to bridge that gap with our agricultural community. It's very disappointing. And you can wonder why our ag sector, when it's taken 2 years for a simple request to appoint somebody from agriculture to a standing advisory board, has not been done, why they don't trust the EPA. It's very, very disappointing on my end. I would hope that by the next time we meet, and I know we will, that we could see much more progress on this. 2 years has been long enough, and agriculture deserves that attention that you mentioned you want to give it.
Yep.
You would prove it a lot by accomplishing this task.
Yes,
and getting somebody in ag on that science advisory committee. So with that, I want to make my chairman very happy by yielding back the remainder of my time.
Chairman yields back. Ms. Yoho, 5 minutes.
You.
Thank you, Mr. Chairman. I appreciate it. Ma'am, thank you for being here. First, I thank you for your agency's work and continued efforts in combating citrus greening in my state of Florida. Experts believe that over 70% of our groves are infected, and we have seen a dramatic decrease in production. USDA estimates that this season's harvest to be 69 million boxes, and that's the smallest crop we've had in 50 years. That's down from the 240 million boxes. Could you speak to what your agency is doing to help the situation? I know you guys are doing good work on that. Is there anything that you need from us to help facilitate that?
Sir, I think, are taking this situation extraordinarily seriously, as you indicate that it is. And I know that we met with the Florida Senate and House delegations to talk about what we've already done on recent registrations, to give more tools, bring more tools to the table. But we're also in the middle of looking at an emergency exemption request that will look at the potential to authorize use of antibiotics. And we're working with both CDC and FDA, which is the process for that. And we're going to try to get that done as soon as possible.
I appreciate that. And if we can help facilitate that or extrapolate work from, other crops, whether it's the apples or the grapefruits or any of that, our state and those people that love oranges would be greatly appreciative.
We're happy to call on you. Thank you.
And I'm concerned that my farmers are not getting access to the tools they need to provide food for the world. Without the pesticides and other scientific advances, 40% of global crop production could be lost because of the effects of weeds, pests, and disease. And I understand that the average research and development cost for just one new pesticide crop protection product to reach the market is roughly $256 million, and the average time frame for a pesticide to be approved by the EPA and reach the market is about 10 years. And I understand we have to do our due diligence to make sure that a product is safe, but we've had products that were approved by the EPA and then pulled after this kind of effort. And what are your thoughts on that?
Well, we certainly should look at what the full range of effort has been and what the average is, but I'd want to look at more recent data and see if we've been able to do a much better job at advancing that. It is clear we want to do our job to make sure that it's safe and being effectively applied.
Absolutely. I mean, we need to do that.
But I don't think that the timelines you've indicated are the timelines that the agency operates under at this point, sir. But if there's more work that needs to be done, we should do it.
And then I just want to I'm concerned about how long it takes for the EPA to approve new products, as we just talked about, for the farmers or the growing communities. And I'm also concerned that the EPA is drifting away from its goal set by Congress, which includes basing decisions based on sound science rather than on input from outside groups trying to limit the use of the safe options for farmers. Some of the nonprofit groups will oppose the use of pesticides no matter what their value in protecting U.S. farmers and addressing world hunger, no matter how safe they are. But those interest groups should know that the crop protection can greatly reduce malnutrition for millions of children and adults over the next few years by safely protecting crops and safely increasing yields. They will also keep costs in the U.S. lower. Will you commit to me today that as the law requires, you will base your decisions in the EPA on sound science and only on sound science?
Yes, it's sound science in the law.
And we see this, with some of the pesticides that the outside groups are saying, oh, this is bad,
neonicotinoids on the honeybees.
Sir, I want to indicate that relative to your first question, one of the most important things is to get new chemicals onto the market that are much less harmful and much more effective. So you're absolutely right on both those questions and their linkages, and that's what we have to work toward.
All right, and I would like for you to show strong leadership. Your agency has so much power to put a pause on the WOTUS, as many people have talked about in here, with 26 states suing the federal government and the EPA until we can reach a better solution. If you could just back off, and I would agree with Mr. Kelly, you know, the things he brought up. And then the standard of testing methodology that we've seen in the lead situation in Michigan, what I've seen is you got to run the water or don't run the water. There's not a standard that everybody's using, and if you don't have a standard, you get skewed results. So I hope you address that, and I'm out of time, and I yield back.
We have grave concerns, and we will.
Gentleman's time has expired. Mr. Allen, 5 minutes.
Thank you, Mr. Chairman, and thank you, Administrator McCarthy, for being here today. And of course,
Oh, there you are. Sorry.
Yeah, right here. So.
I'm so sorry. I don't know how I lost you.
Well, those lights are kind of bright. But anyway, we, you know, I've learned a lot here today at the hearing. I hope that you and your staff are taking good notes and learning a little bit about some of the things that we have to deal with. I'm a new member of Congress. I'm from Georgia. And of course, you've heard the concerns about our farmers and others. But what I have learned is there is an obvious disconnect between the American people and your agency and your ability to carry out the laws that are established by the United States Congress. I guess my question is, what have you learned from this hearing today, and what do you plan to do about it?
I think that I have learned that we have significant, not just differences of opinion, but an understanding of what the agency is doing, our intent in doing that, and that we have a lot of work to do to have a trusting relationship, to both be able to talk to one another, but to listen to those concerns and effectively get them into our policies and regulations.
Would you do this for, we're the people's house, and we report to the people. What I'd like to see is a plan by your agency to do just what you said you plan to do. In other words, if you would lay out a strategy somehow that we're going to get on the same page, and how we're going to do that, because we have differences in science. You have an important job. There's no question about it. We have issues. We brought those issues before you today. I mean, Flint, out in Colorado with, you know, there are mistakes that have been made. I will say that just from my observation as a long-term member of the business community, that you know, part of that strategy needs to be prioritization. In other words, you're doing things that are affecting the economy and affecting our farmers' ability to operate their farms, but then you're letting these other things slip through the cracks. So I think you need to reprioritize your systems, and I'd like to see that in your strategy. The other thing, the last question that I have is relative to the economic impact. When you, like, say, waters of the U.S., I mean, again, we've talked about, you know, where did that rule come from? And you need to understand that, you know, over half of our farmers are retiring and have been since 2009. And only 56% is there a second generation that's coming along. So obviously, and you feel our frustration, and our frustration is their frustration. Because, I mean, when you start talking about taking people's property away from them because they have retained water so that they can sustain their farm, that is a serious, serious issue. You got millions of comments on the thing and continue with the rules. So you can certainly understand that the concern there. But from an economic standpoint, I mean, is your agency at all connected to the fact that this economy is growing at less than 2% and has been for the last 7 years? And that, you know, what responsibility does your agency have for that lackluster growth? Have you actually gotten together and talked about, and is the growing of the economy important to you?
Always, yes.
I mean, these are jobs we're talking about. We're talking about every American deserves the opportunity at a good job. We got, some say 90 million people who are not working today. And one of your strategies that I would recommend is that you go back and look and see what your agency could do to grow this economy and how you could grow the economy. And any further comments as far as what you're going to move forward? Well, I've got 44 seconds remaining.
No, sir. I will certainly take to heart what you suggest. I do think we try very hard to understand how we can meet our mission, but do it in a way that actually advances the economy moving forward. But I have no question that there are challenges in agriculture, and that those challenges have to be part of the discussion we have when we interact with this sector.
And you realize that has to be a bottom-up approach. In other words, the farmers have to be included in that process.
Yes.
I yield back, Mr. Chairman.
Gentleman yields back. Ms. McCarthy, we're almost there. Two more questioners. Dr. Benechek.
Thank you, Mr.
5 minutes.
Chairman.
Thank you, Mr. Chairman.
Hello.
Well, welcome, Ms. McCarthy.
Thank you.
Last September, the EPA published an interim recommendation for environmental standards and eco-labels for use in federal procurement. And one of the recommendations for lumber excludes several credible standards that are widely used in the United States, including the Sustainable Forest Initiative and the American Tree Farmer System standards. And we understand that this recommendation was made without consultation with the Department of Agriculture, who not only have a lot of expertise in forest management and forest project, but it also publicly stated that the Sustainable Forest Initiative and the American Tree Farmer System standards can be used to verify sustainability of forest products. Furthermore, it's supposedly based on a determination by the Department of Energy that has no formal analysis behind it. So can you explain the basis of this recommendation for federal procurement?
Well, sir, I do know that it is related to the federal government wanting to make sure that their purchasing reflected the full range of interests of the public.
But we already, the Forest Service or the Department of Agriculture has already determined that, this is a sustainable thing. So what other factor are you taking? We
were actually utilizing a certification program that was up and running that we thought had credibility because of its history, but we've recently been asked to consider opening that up to other certifications.
What is the certification program that you're using?
It's basically a third-party certification.
So which one is that?
I apologize.
I mean, these are the two most widely used certification processes in timber management in the country, the ones that I've outlined.
Yeah, and we're certainly opening up the discussion so that we can expand that. We have no interest in taking away the opportunity to use legitimate and very well-tested third-party certification.
Why wouldn't you consult with the Department of Agriculture prior to making this kind of a rule?
I'm not sure that wasn't done, sir, but I certainly can check. Well, and you're right. If it's a forestry issue, we should be consulting appropriately with all the right federal partners on this.
So when is that going to be fixed then?
Say it again?
You said you're going to look into it. So when is that going to happen?
We already are looking into it. I just can't put my finger on it, sir,
right.
But I know that it's part of the work that we're doing ongoing. I can get back to you on what the timeline might be.
So is the timeline a month?
I don't know, sir.
3 years?
Back to you. I can get back to you.
All right. I'll yield back.
Gentleman yields back. Ms. Lamalfa, for an additional 5 minutes, you had a couple of other questions. Doug?
Thank you, Mr. Chairman, for your indulgence. Ms. McCarthy, once again, I will try and just keep this to asking for an offline clarification and then a couple yes and no's. So I appreciate your time and that your grace with what you've answered the questions today. Just to bring your attention quickly, a presidential memorandum recently issued. It's called the Mitigating Impacts on Natural Resources from Development and Encouraging Related Private Investments. So I don't expect you know this on the spot here, but again, mitigating impacts on natural resources from development and encouraging related private investments. It's a fairly new presidential memorandum. It appears to be carrying the weight of an executive order and seems like a really quite a significant departure from current policy looking like it's going to go back and reassess every possible impact that a man-made activity might have on public land or any natural resource on federal projects. So do you plan to follow this policy, and can you walk me through in a letter later on how you do plan? Are you aware of that title?
I have not been made familiar with the details, so I'll have to get back to you on how my agency would respond. We have very little ownership of federal lands.
Okay. Well, it might have an effect on all federal lands, so we're still catching up to. I'd appreciate if your office can clarify to that in a letter offline here. And on the previous questions I had on Clean Water Act, again, regarding plowing, and this is very important to several of my constituents have gotten in some hot water up in the district there, on the 404 exemption of the Clean Water Act. Current Clean Water Act regulations provide that plowing, in quotes, will never involve a discharge unless it changes any area of waters of the United States to dry land. So I'm familiar with that with growing rice that along about 1985, the sod buster, swamp buster regulations came in through FSA where we're not to, take swamps or change waterways, things of that nature, big things. So, but since we do have this 404 exemption, does this regulation really truly mean what it says? Because that's what my growers are wondering, that there is an exemption for 404 under plowing.
My understanding is for plowing, yes.
Okay. Was this regulation intended to assure farmers that their plowing would not be regulated under the Clean Water Act?
That would be its intent, yes.
Okay. So, and I might be repetitive here, but I have to do this. So does it mean that plowing is not regulated under the Clean Water Act unless it actually changes waters to dry land?
Waters to dry lands?
Something deemed as waters of the United States. If it's changed it from water, it's exempt
or the
unless
other
you're
way
doing
around,
something.
change land to water.
Water, yeah, a watered land to a dry land, which is what I talked about maybe in the swamp buster, sod buster, and FSA. So you agree with that?
Yes.
Okay.
I think.
Can farmers continue to rely on this regulation? This is the important takeaway here. Can they continue to rely on the regulation as interpreted under 404 as an exemption and continue plowing their fields?
Yes.
Okay. All right, Mr. Chairman, thank you. Thank you for your time and indulgence. I yield back.
You bet. Chairman yields back. Just another up here. Another couple of quick ones real quick. We were talking to Mr. Desjardins earlier about water jurisdiction. You said that biological, chemical, and physical indicators must exist to determine if the water is jurisdictional. Yet the rule uses biological, chemical, or physical. So can you clarify which is which?
It would be an or.
Or, okay.
Yes.
All right, so that would...
It basically means that you have an ability to pollute or destroy the downstream water.
All right.
That's right.
So or is a much broader interpretation. Also, I know you're tired of talking about the GAO report on social media, but
yes.
One of the things that whatever you do, however you do it, there ought to be an audit trail, there ought to be a path by which we can track back to how it happened and who happened, all those kind of good things. But use of a tool like Thunderclap, which hides that, can you commit that whatever you're going to do with social media that you'll leave in place, or you'll use tools or leave in place a audit trail, an ability to see where it came from and who did it within your organization? Are you, and not using...
I certainly can. I certainly know who worked on these issues internally.
Well, I know that, but
and GAO really was concerned that a retweet
right.
was not able to be tracked back to EPA. So one of the things I tried to explain, although I don't agree with GAO, I'm not disrespecting their decision. So we'll work with OMB. It's OMB, Office of Management and Budget, that did the guidance on how you use this Thunderclap. Okay. And we followed it, and we'll make sure that we address these.
There are other innovations coming in. There's one called Kick and others that allow you to anonymously do things, and we don't want our federal
The one thing you can be sure of, it will never be me.
Oh, no. I got you. Well, second, let me apologize for how cold it is in this room. There are other offices in our suite that are like ovens, and so apparently our system doesn't know the difference between wintertime and summertime. So
I can now care
I
of that.
apologize that.
That's okay.
We do have a number of members who have, and we, the committee, have a number of questions we'd like to submit for the record. We'd appreciate a timely response to those. Nothing like you don't have enough to do. We're going to add to that, but we would like a timely response to that. Again, thank you for being here this morning. I know you anticipated that this was not going to be the most fun you could have on a Thursday, but
I thought it was incredibly informative and respectful.
Well, thank you
so
very
thank
much.
you.
You're very kind with that. But thank you for being with us for 3 hours this morning. Appreciate it. Under the rules of the committee, the record of today's hearing will remain open for 10 calendar days to receive additional material and supplementary written responses from the witnesses to any questions posed by a member. The hearing on the Committee of Agriculture is adjourned. Thank you.